Hello, everyone, and welcome to Uncivil Law. I hope you, as always, are having a great day. And we are here with the latest in the ongoing Amyiah Cohoon incident. As we last remember leaving the action, we had a situation with Amyiah. She had posted a Instagram post from a hospital bed that said that she had COVID. The police came to her house and demanded that she take down the Instagram post. She did, in fact, take down the Instagram post, and she is now suing for violation of her deprivation of rights. So Amyiah has responded, or to be more proper, has replied, to put it in the proper legal parlance. She filed the initial complaint. The government responded, and she has replied. And she and the government have both asked for summary judgment. Both sides say the facts are in. We don't need any more facts. We want an adjudication on the law. Okay, so we're going to do that. We are going to adjudicate this issue. So Judge Blackleaf, that is me, Judge Blackleaf is now sitting, and Judge Blackleaf is going to provide his legal opinion. Now, I wish to state very, very clearly and unambiguously at the top that my legal opinion as a judge may not necessarily reflect my own view of what should be. A judge should interpret the law and apply the law. So I'm going to give my legal opinion as though I were a judge. It doesn't mean I necessarily think it's right in a moral sense or in any sense other than the law. This is what I think the law requires. Because I have a sneaking suspicion going into this, I'm going to rule against Amyiah, and I don't really want to. But if that's what the law requires, that's what I'm going to do. But, of course, we have to read her reply because we've only read so far the original complaint. We've read the government's response. Now we'll read her reply. We'll read what she says are the issues. They both have proposed statements of fact. They have both provided what they think the facts are. So we will adjudicate, or I will adjudicate what the facts are, in my humble opinion, because we've seen the video, we've seen the original filing, so we can adjudicate what the facts are. And then I, Judge Blackleaf, will render a legal decision and probably wind up irritating everybody. So let's do that. Let's irritate everybody. This is the reply brief. This is the reply and all that good stuff. So yes, she is suing federally for 42 U.S.C. 1983 as her cause of action. 42 U.S.C. 1983, a government actor has deprived me of my civil rights. The civil rights in question would be the right of First Amendment freedom of speech, the right not to have my photograph seized, because I would argue that being forced to delete the photograph qualifies as a seizure. So there's a First Amendment interest here. There's a Fourth Amendment interest here. Maybe there's a deprivation of property interest in there. Fifth Amendment, possibly, for compensation of taking. But First Amendment is our big one, freedom of speech. So we're suing 42 U.S.C. 1983 for violation of civil rights. Our violation of our civil rights was when the police came to our house and made us delete the post. That's the argument. So we'd like to have that, be adjudicated. Great. I'm going to do that. All right. So here is her brief, or her reply brief. The Cohoons, or Coons, I'm not sure how to pronounce their name still, I apologize, but we'll go with Cohoons, I guess, today. Cones? The Coons? Cones? The Cones. I don't know. The Cohoons filed this First Amendment action on behalf of their 16-year-old daughter, Amyiah, because a deputy sheriff came to their home and demanded Amyiah delete her social media posts about her scare with COVID-19 and even threatened citation or arrest if the post was not removed. One of the benefits is that we have seen the video, because I requested it and obtained it, and we reviewed that previously. So we've actually seen the video. That's super helpful. The Cohoons first attempted to resolve this issue without litigation, but the sheriff refused to acknowledge the violation. We know that to be true. Their attorneys did try to resolve this, and the government was very obstinate to admit that Amyiah's speech about it was protected or to provide any mitigating explanations for the actions of the deputy. That's true. They didn't try to mitigate this, which I really think they probably should have, irrespective of anything. It's generally, I mean, this situation would have cost you very little to try to mitigate it, and it would have produced better feelings. So I think an attempt to mitigate this would have been helpful, but they didn't want to do that. So, okay. In the complaint and declarations in support of the injunction filed almost 3 weeks after the incident, the Cohens recounted what happened at their time as best they could recall. Yeah, fair enough. Their original complaint was what they thought occurred. We've seen the video. Their complaint was not exactly what occurred. But then again, the government's response wasn't exactly what occurred either. Defendants have moved for summary judgment based on a video recording of the incident that they argue undermines the Cohens' factual account and defeats their First Amendment claim. Yet the video confirms the First Amendment violation, proves the Cohens, not defendants, are entitled to summary judgment. Both sides want summary judgment. Fine, we can do that. The video shows Sergeant Clump threatening Rick and Angela if Amyiah's post didn't come down, the sheriff has directed me to issue disorderly conduct to citations, if not start taking people to jail. That's true. The time on when that occurred is going to be pretty material, though. Defendants placed great emphasis on the fact that the threat was made to Amyiah's parents and not directly to her, and claimed that Amyiah had already agreed to voluntarily delete her post, which kind of, but it might have been taken back if we get into the issue of consent. I think qualified immunity is still going to be the big problem. So Amyiah's lawyers have to get around qualified immunity or they're done. If they get around qualified immunity, then we can start arguing about the issues about consent and whether it was consensual or under duress and blah, blah, blah. But if we can't get past QI, we're done. So Amyiah's lawyers have to get past QI, which I think is going to be really challenging. But the latter is a mischaracterization of what occurred, and the former is irrelevant. The video shows the first thing Amyiah heard from Deputy Sheriff at her doorstep was a demand, not a request that she delete her post. It depends how you characterize that, but whatever. And without any reflection, she immediately agreed to do so, as any 16-year-old would do. Her father objected, but her mother said yes. So not only the 16-year-old, but her mother. I distinctly remember hearing more than one voice say yes at that moment. It wasn't just Amyiah. It was also her mother. Her mother says yes, her father says no, Amyiah says yes. That's good news. And in her presence, the officer had no authority to issue such a demand. That's true. But QI, though. Amyiah went inside to delete the post only after Sergeant Clump insisted that he did have such authority. There's no question Amyiah became aware of the threat while Sergeant Clump was there. Fair enough. The video shows Amyiah's father's protesting the threat of jail in front of her. That's true. Sergeant Clump did not deny making the threat. True. He confirmed it. Maybe. Depends on what you mean by confirm, but fine. And he even told Amyiah that he didn't want anyone to get into trouble. Yeah. Once Sergeant Clump left the home, Amyiah deleted another earlier post, and the sheriff continued refusing to acknowledge the speech was protected, even in the most recent filing that has an ongoing chilling effect. Maybe. That's a ray of hope for Amyiah in terms of trying to keep this alive, at least for declaratory relief of something. Thus, it won't do you any good going backwards, but maybe going forwards. Yeah. All right, so background. A lengthier description of the circumstances leading up to this incident at the home is set forth in the brief in support of their motion for preliminary injunction and in their proposed findings of fact. We have seen all that good stuff. In short, Amyiah, a sophomore at Westfield Area High School in Westerfield, Wisconsin, went on a spring break trip to Florida, and a week later began having symptoms consistent with COVID, including fever, dry cough, and significant difficulty breathing. She visited the hospital twice, first on March 22nd and again on the 25th. During her first visit, the doctor said her symptoms matched COVID-19, but they could not be tested, so they sent her home with instructions to strictly self-quarantine. Her symptoms became much more serious 3 days later, showed she was ambulanced. I don't remember that particular detail before about her being ambulanced. I remember them saying that they took her back to her, but I don't quite remember the ambulance part. I don't know if that's new information or if I just forgot, but either way. She was ambulanced from the hospital in Portage to the Children's Hospital in Madison, where she was finally tested. Her test came back negative, but the doctors told the Cohens that they still might have missed the window for testing positive, so the Cohens continued quartering. Jan, I keep saying Jan, that's my fault. Jan Negriri asks, if Scottus resolves QI before the appeal is finalized, does she have a chance? Depends how they do it. Depends on how they do it. Maybe. Yes. Maybe if, depending on exactly what the Supreme Court does. But I don't know that they would announce something that would have backwards looking effect. So my suspicion would be that no matter what the Supreme Court does, it won't help Amyiah because it won't have backwards looking effect. But I don't know that for sure because who knows what the Supreme Court's going to do on QI. But I don't sense in the water, basically I'm reading tea leaves. I'm reading the tea leaves. But I don't sense from the tea leaves that the Supreme Court is looking to do something quite that drastic. I think they're looking to do something a little less drastic. So we will see if they want to do something, but I don't think it's going to backwards looking effect. Amyiah posted 3 updates to her Instagram account throughout her experience. On March the 22nd, she posted that she had COVID-19 and was in quarantine. On March the 25th, she posted that she was going to the ER. And on March the 26th, after she returned home from the hospital in Madison, she posted that she had beaten the coronavirus, stay home, stay safe. A day later, on March the 27th, let's try the other way around. Defendant Deputy Sergeant Cameron Klump, Mr. Klump himself, came to the Cohens' home with a screenshot of the post, demanded that Amyiah take it down, and even threatened citation, arrest, or jail if it did not come down. Amyiah deleted her post, and after Sergeant Klump deleted her first post out of fear that she would return and follow through the threat. Later that evening, the Cohens learned that Bob Miker, the administrator of Amyiah School District, had sent out a blast news update stating the post was a foolish means to get attention. There's no truth to this. Which, from his perspective, yeah, it's okay. It's not great, but based on the information that he had, QI, I think, because he is a government official, I'm going to assume the QI applies to him too. Amyiah wanted to respond to these accusations, but she's felt unable to do so given the threat. She's responded in court, and I'm covering it for all the good it's doing. On April 3rd, undersigned counsel sent letter to Sheriff Conrath on the Cohens' behalf. The letter described the Cohens' recollection of what happened on the 27th and asked the sheriff to either acknowledge the violation or provide some assurance that they would not cite, arrest, or jail the parents for sharing the story. They further asked if any portion of the recollection was inaccurate, the sheriff explained, and provide any and all documents in your possession which would show belief as to the facts under Wisconsin's open record law. The sheriff denied to acknowledge the violation or provide any mating explanation. Instead, he hired counsel who responded that the speech was not protected, but is the equivalent of shouting fire in a crowded movie theater. The only thing the letter offered was the investigation, but of course the investigation did not exactly state what unlawfully deleted the post. The records Sheriff Conrath provided in response to the Cohens' open record request confirmed all the material facts necessary to support the violation. Sergeant Klump's contemporaneous incident report stated he went to the home at the Sheriff Conrath's direction to have the post removed from the media. And though they advised, if not willing to do so, there'd be the possibility of ordinance. Yes, we saw that. Sergeant Klump has asked Sheriff Conrath to review the incident report to see if you'd like any corrections. I've reviewed your thing and it's accurate. So it sounds like the Cohens' lawyer, for reasons that are unclear, did not get a copy of the video in response to their open records request. But I got a copy of the video in response to my open records request. That seems a little bit odd. I don't know why that would be. But I was able to get a copy in response to my open records request, but they can get a copy of the video in response to their open records request, even though that they would have a slightly greater interest in the video. And I say slightly greater interest advisedly because it's public records requests. So in a strictest legal sense, they don't have any greater interest than me, and I don't have any greater interest than them. But on a practical level, they have a slightly greater interest because of the lawsuit. So that's what I mean by that. Speak slightly slower. I will do my best. Thank you, Jan. On April the 16th, the Cohens filed this action along with a temporary injunction motion, explaining that as a result of the prior theft and the unwillingness to acknowledge the First Amendment violation, Amyiah reasonably fears that another deputy may show up at her door if she posts anything in the future about her experience or responds to the accusations her posts were false, which is presumably not 100% true since she has responded through this lawsuit and presumably the sheriffs have not showed up at her door again. Then on April the 24th, defendants filed a motion for summary judgment based on the video and audio recording, which they say undermines the description. it is the most pertinent piece of information in this story. It's not necessarily the only pertinent piece of information, but it's pretty much the most important piece because that goes to exactly who said what to whom and when and what exactly was being exchanged and all that great stuff. And we have a copy of the video. So we do have all the information that we need to form a summary judgment. I have all the information I need to form a summary judgment, right? I have the video. I have the emails from the Amyiah's lawyer to the sheriff and their replies. I have the incident report. I have the Instagram photo. I have all the things. I am now just as informed as the judge. I'm very excited. I have all the things. I have all the declarations from the various people. I have all the things. It's not that complicated a case. There were additionally some other affidavits that we haven't reviewed. I've reviewed them. I'm not sure how material they are to anything, but if they comes up, we'll discuss those too. But yes, we have all the information we need to adjudicate this issue and provide the legal answer. Yet, apart from a few minor inconsistencies, the videos confirm the recollection. And establishes beyond forward a straightforward First Amendment violation. That's true, but QI, though, is going to be your problem. The video shows that, consistent with the incident report, Sergeant Klump came to the home to have Amyiah remove the post from social media. Sergeant Klump first spoke with Rick Cohn, Amyiah's father, and began the conversation by noting the sheriff's office was aware, maybe having the COVID stuff and having gotten tested. Rick explained Amyiah was just returned from the hospital the day before, but Sunday was when all this started. Amyiah was having problems breathing, a fever, dry cough, so they took her to Divine Savior Hospital in Portage. Rick explained that the doctor's best guess was that they had COVID, but they didn't test her, so it's not an actually confirmed test. Rick then describes 3 days later how they took her back to the ER to Portage because she was again having difficulty breathing. The hospital took her blood labs and found that her white blood cell count was low, and still believing that she had it, they ambulanced her to the Children's Hospital in Madison. Rick then told Klump that Amyiah was finally tested on Wednesday evening, and the test came back negative the following morning. Rick explained that the doctors at the hospital believed that she may have COVID-19, so they told her to continue quarantine. Sergeant Klump then explained to Rick and Angela, who was outside at that point, that he was at their home because Amyiah had posted that she had beaten COVID-19. Rick immediately responded with, well, that's what they're telling her. Sergeant Klump then began arguing with him. Yeah, well, but she began negative. It wasn't like she tested positive, was in the hospital like all these other people, and now has been released. It was a little bit like that, but Rick attempted to explain for a second time they didn't test like they should have because that's the way they're doing this. There's no way to prove who has it and who hasn't have it. Also, the COVID tests are not particularly reliable, although I'm not sure that this was known at the time. Again, we have to put ourselves in the position of the things that occurred at the place and the time. So we have to ask ourselves, was the lack of reliability of the COVID test known at the time this incident occurred? I'm not sure the answer to that question is yes. I'm not sure that they were known for their fairly high fail rate at that point. So that might be material. Again, in terms of the sheriff's ability to rely on that as being definitive. So if it wasn't known at the time that those were not accurate, then their ability to rely on that to make the decisions they did seems a lot more probable. So, undeterred, Klump went on, the concern is that we have parents whose kids were in Florida have seen this and now they're calling the school. Rick jumped in to say that they had already called the school, but Klump pressed ahead. Just let me talk. They're calling the school. Why aren't we being notified? Klump then told the Cohens that he was there to get her to delete this and asked them to post a new post, apologizing and saying it was not actually positive. Rick stated, well, we don't know that. We're not going to do that. We don't know that. Klump shot back, but you say the test results came back negative. 5 days later, Rick repeated for the third time, when we had to take her back to the ER and she got ambulanced to Children's Hospital for 2 days. She didn't put in Children's Hospital because she didn't have it. They believe she had it. She just tested negative by the time someone tested her. A little later, Angela brought up Amyiah for the first time. When she came out, Sergeant Klump was arguing with Rick about who was getting tested and why, and Amyiah listed to them until Klump stated, audibly frustrated, I don't know the circumstances you were in. All I'm trying to figure out what this post is, seeing she tested negative and we need to get it taken down. Thus, the first thing Amyiah heard from the deputy sheriff, who had just been arguing with her father, was a demand to delete her post, not a request, as defendants have characterized it. I think it's fair to look at it as a demand. As any 16-year-old will do when issued an order by uniformed law enforcement, she quickly said, "Will do." And also her mother, because I heard two voices. So it wasn't just a 16-year-old girl, it was a much older girl, her mother, who said the same thing at the same time. Wasn't great. Klump then began explaining directly to Amyiah the reasons for the demand. The parents are concerned you're saying that you had corona and they aren't being notified. Angela then interjected, "Well, they should have been notified because I talked to the principal myself personally." Klump responded, "We're all aware because he contacted the sheriff." Rick then stated, "We talked to everyone, no one gives a care. No one wants to be the person to have the information available. So if the parents call and say, 'Hey, is there other cases?' Because she did positively test, have it. We don't know where it came from. I would have given it to her. I work at the casino. We didn't close down until a week ago, Thursday." I hadn't had the symptoms. Angela hasn't had any symptoms. But with her working at the gas station, me working at the casino, it could have very easily come from there. Now, I find it very silly and asinine to be arguing about a silly little post because it's upsetting people. Well, people need to be upset because they need to understand what's happening to her. You know, the father definitely has the better position here in terms of all the things. But again, he's in a different position of information. So we have to look to all the respective people and what information did they know and when did they know it at the time, what was known and what wasn't known, and who was acting reasonably and who wasn't acting reasonably. We are trying to adjudicate this based on who knew what and when. These are critical questions as we're trying to adjudicate this. So we know in retrospect his position is better. But at the time, whose position is better? A half minute later, Klump interrupted. "Nonetheless, can we get the post taken down?" Both Amyiah and Angela quickly said yes, but Rick objected. "Wait a minute, why does it have to come down? What has been violated here lawfully?" Klump responded in a cautionary tone. "Because the health department has information of her test results, she's not positive. But they don't have the information from what was originally seen," Rick stated for the fourth time. Klump said, "I guess you're not understanding me," to which Rick responded, "We're not understanding each other," which, as I said at the time, I thought was a really great response from Rick. Way to go, Rick. I thought that was a great response. It is a great way of responding to that in a way that is not disrespectful, but is witty. I like this response very much. It's not antagonistic, but it responds to it. You're not understanding me. We're not understanding each other. I like that response very much. Plus 10 points to Rick. Also, plus 10 points to Rick for being aware of the Constitution and wanting to defend his rights. Good job, Rick. You were doing well. Amyiah's mother left a little bit to be desired on the defending the constitutional rights front. Sorry, Amyiah's mother, but you could have done better. Rick was doing pretty good. Rick was doing pretty well in this situation. Kudos, Rick. Angela then told Amyiah to go inside the house, and she began stepping inside. Klump said, "Rick, I don't want to go this far. It was simple as me coming out here and just getting the post taken down. And I don't believe the post needs to come down." Sergeant Klump then directly threatened, if it doesn't come down, the sergeant has directed me to issue disorderly conduct, if not starting to take people to jail. Fair enough, too. After hearing this threat, Angela waited a moment to see if Rick would continue to resist the demand, and seeing that he did not, she went back inside, briefly poked her hat and said she's taking it down now. Mrs. Cohen is not doing great. Rick is doing better in defending his rights, and Amyiah's mother is undermining the situation, which is very legally significant because they both have. I would presume, right? I presume they both have equal guardianship rights, which means that either one is able to undercut the other when it comes to being a guardian. So if Rick says no and she says yes, then the police can reasonably rely on either one. And obviously they're going to rely on yes. So when you have two people with authority who are undermining each other, then dealer's choice. So, not so great. It's going to be a problem for Amyiah's complaint. For the next 6 minutes, while Angela and Amyiah were inside, Rick continued to try to explain the situation in a very rambling way. This was Rick not necessarily at his best at this point. He was just rambling and frustrated, which I understand, but yeah. Anyways, that the children's hospital believed she had it, but she wasn't tested for it. By the time she tested that, she was negative. And for a sixth time, that the hospital said she has it. The problem is they can't prove it because the test was done. He insisted that should be the entire issue, which it really should be. But you want to turn putting information out there to forewarn other people into creating a disturbance, and you're going to jail. Rick has some solid points here. Rick has some solid points. Rick's doing good. Still unpersuaded, Clump eventually said, "Can she bring up the phone and show me that she's got it down?" Rick then went inside for about 30 seconds, and Amyiah came shortly thereafter. It's been completely taken down, and showed him the phone to verify. After Amyiah took the post down, Sergeant Clump said, "I appreciate you taking it down. Like I said, I don't want anyone to get into trouble." While Amyiah was still outside and in her presence, Rick continued to express frustration with the threat. "You got a student in the school that's possibly positive, most likely was. You guys want to threaten someone with jail and add insult to injury." Cute, witty. Rick gets points. Rick gets points. Since I know where Rick lives, maybe I should send Rick something in the mail. Would that be creepy? If I send something to Rick in the mail, would that be creepy? I don't know. I'll have to think about that. Maybe I should send him something like, "You go, Rick. Way to go, Rick. I support you. First Amendment forever." Send him a framed copy of the Constitution or Bill of Rights, maybe. That'd be good. So he can put it on the wall so other people can look at it admiringly. Maybe I'll send Rick a gift. And a minute later, he said, "People want to know what is going on, and doesn't do any good when you warn them, when you got the sheriff's department threatening to throw people in jail. I'm just doing what we can as the sheriff's office, okay?" In other words, he did not deny he threatened people in jail, but confirmed it. As Sergeant Clump left, he deleted the first post, afraid that they would return and follow through on the threat. Good times. Argument. All right. Yeah. Argument. Plaintiff is entitled to summary judgment based on the video alone. The video shows a clear First Amendment violation. Yeah, I think it does. Defendant does not. Yeah, now we're trying to adjudicate the law and adjudicate the facts. We're being judged Blackleaf. That's me trying to adjudicate this. Defendants do not dispute the well-established First Amendment principle that law enforcement may not penalize, threaten, protected speech. Nor do defendants dispute, in light of video confirmation, that Sergeant Clump came to the home and told them that if the post doesn't come down, the sheriff has directed me to issue disorderly conduct to people, if not starting people to jail. Yeah, when exactly that statement concerned and consent and a whole bunch of other things flow. But the big issue I'm still trying to get past is qualified immunity. Defendants also implicitly concede that Amyiah's social media post was protected by the First Amendment. In the merits portion of their brief, defendants entirely skipped the first element of the claim, failing to discuss even whether they engaged in protected activity. Defendants never affirmatively argue the post about her scare was outside the scope of the First Amendment, so it should treat it as conceded that it is. Fair enough. I accept it. I accept that it was protected by the First Amendment. Fine, no problem. Even if defendants did not implicitly concede this, the posts were unquestionably speech protected by the First Amendment. As the Supreme Court has recognized, social media is the principal source for speaking and listening in the modern public square, particularly in these times where it's even more the modern public square. That is especially so during the ongoing pandemic and the stay-at-home orders, where social media is one of few avenues for communicating with the outside world. And while certain categories of speech are excluded from the First Amendment, obscenity, defamation, true threats, inciting violence, none of these exceptions apply to the post. Presumably at the time, they thought it was in the realm of incitement or violence or something along those lines. Through her post, Amyiah simply wished to share with her family and friends the significant scare she had with COVID-19, and such speech is presumably protected by the First Amendment. I agree it is. Given that Amyiah's post was protected by the First Amendment, there's a video showing the threat if she did not remove the paywall. This should be an easy case. But QI, though. But QI. And I know you know that, attorneys. I know you know that, but you're avoiding it so far because I suspect it's not going to go well. Yet defendants argue, indeed their main defense, is that they are absolved of the First Amendment violation because Klump did not state this threat directly, but to the parents. That is also an issue. The fact the guardians were there also provides a buffer. So yes, that is a material fact. The argument fails for three independent reasons, all of which were self-evident. First of all, even putting aside the threat, a demand from law enforcement officers standing outside one's home to remove social media posts is more than enough of an implicit threat to cause any 16-year-old to censor the speech and unquestionably cause Amyiah to censor hers. The fact the parents are there is a very big mitigator, though, because the parents are in a position, legally, to stand up for Amyiah, or not. And or not, unfortunately, is going to be an issue. But we don't even have to get that far if we don't get past QI. We have to get past QI before we even start asking questions like consent, duress, one parent acting in light of another parent, and all that's time. We don't even have to start asking those questions if we don't get past QI. QI is a killer, man. Qualified immunity is a killer. Contrary to the characterization, Sergeant Klump did not merely ask, but the first thing they said was the demand, we need to get it taken down. And this demand came right after an argument with her father, in which Sergeant Klump was arguably audibly frustrated, further impressing on the seriousness of the demand. If there were any lingering questions about Sergeant Klump was asking or demanding, his subsequent exchange with the father in her presence removed all doubt. After Sergeant Klump brought up deleting the post again, Rick protested on her behalf. Wait a minute, why does it need to come down? What has been violated here lawfully? Sergeant Klump did not respond. Oh, nothing, I'm just asking you to remove it, but it's up to you. Oh, I apologize. I misunderstood that in my own head. Let me reread that. So, Sergeant Klump did not respond by saying, oh, nothing, I'm just asking to remove it. It was up to you. So he didn't say that. Okay. Instead, he repeated slowly, the health department was aware of Amyiah's negative test result, clearly suggesting, especially a 16-year-old, that something had been violated and he was there to enforce it. Which, is not atypical police tactics. Why be specific if you can be vague? If vague works, vague works. Amyiah went inside right after this exchange. Thus, Amyiah did not consent to the request. She acceded to his demand. The timeliness on this thing is an issue of consent and all that stuff. If we actually have to get into the consent issue and all that stuff, then that will be interesting. But we're not there yet. It has long been established that speech is shielded not only from punishments or threats, but protect against censorship. Government officials may not command a person to cease or censor a speech. Second, even though Amyiah may have not heard the threat directly, the video shows that Sergeant Klump played a causal role in Amyiah removing the post. Amyiah's father correctly recognized that Sergeant Klump demand violated her First Amendment rights and resisted that unlawful demand on her behalf. Following his objection, Amyiah's parents did not assent to Amyiah removing the post until after Klump issued his threat. Shortly after Rick said what's been violated here lawfully, Angela told Amyiah to go inside when the adults continued to discuss. Just seconds after Amyiah went inside, Sergeant Klump threatened both Rick and Angela with citation or jail. Angela waited a moment to see how Rick responded, and seeing no further resistance from removing the post, she went inside, came back outside to say she's taking it down, and then returned inside for the next several minutes until Amyiah came down. That is all very, very material, though, when it comes to, again, the ability of consent and the ability of the legal guardian to make legal decisions. So if Amyiah's mother made a decision at that point, again, outside of duress, which maybe there's duress here, we have to get into that issue too. But assuming there's not duress, if Amyiah's mother goes inside at that point and says, take the post down, then we're just done. Because she's a legal guardian and she has the legal right to do that, if it's with consent. Now, and then we have to get into duress and whether there was duress and whether or not it would overcome a reasonable person's perception of Amyiah's mother being the reasonable person in this circumstance and all that great stuff. But we don't have to get into any of those issues until we pass QI. Finally, there's no question that Amyiah learned, while Sergeant Clump was still there, that he had threatened the family with jail over the post. After Amyiah removed the post, Sergeant Clump had a screenshot of. She remained outside while Clump and father continued to discuss. Rick twice protested the threat of jail, and Sergeant Clump did not deny he made such a threat, but instead continued the threat, all in Amyiah's presence. After Sergeant Clump left the home, Amyiah deleted her first Instagram post, the one Sergeant Clump did not have a screenshot of, as his threat has created an ongoing chill of Amyiah's speech, including preventing her from responding to the accusations her posts were false and a false means to get attention. I did request to be Amyiah's Instagram friend. I don't know if she added me. So I should go into her Instagram posts and see what she's been posting. I don't know if she added me or not. I don't know who's vetting these requests at this point. This last point in particular shows defendants' main defense is beside the point. Even if defendants were correct, that Amyiah's initial contact with Sergeant Clump was not sufficient to defer the activity. Notwithstanding video evidence that she did censor her speech in response to the demand, defendants do not dispute, nor could they, the threat of arrest is sufficient to chill speech. The video shows Sergeant Clump confirmed in threat of Amyiah that his demand was backed by the threat of arrest or jail. The threat has cast a shadow over social media use, a shadow lengthened by the sheriff's ongoing refusal to acknowledge the violation. Bobcat says qualified immunity would not apply under the course of action of this suit. Bob, I don't know how to say this to you, but you're just 100% wrong. You are all the wrong. I say it with all the love and respect, because I wish it weren't true. But we have covered many qualified immunity cases on this channel. It has become somewhat of a recurrent theme on this channel, and we cover qualified immunity cases. And we have learned that qualified immunity covers the police in most situations. You have to look for a violation of a constitutional right that is clearly established at the time, and usually you lose on number 2. So nothing in Amyiah's complaint would prevent this from being a QI issue. Now, whether or not QI applies is a reasonable issue. We haven't gotten quite that far yet. Whether or not QI applies, I think it will, based on what we know so far, but we haven't gotten to the end of the page. So maybe it's that QI won't apply. But so far, based on what we know to this point, as your judge for the day, I think QI applies. I'm not saying I want it to apply. I'm not saying it should apply. I'm saying that's what the law demands. So yes, QI is absolutely a relevant legal issue to this. Yeah. Although defendants cease cause and offense defense fails on its own term, the court need not accept the invitation to engage in a microscopic dissection. The court can watch the video's threatening behavior for itself. Fair enough. I've watched it for myself. Defendants' only other argument on the merits is that they have probable cause to cite and arrest for disorderly conduct. This argument fails for a variety of reasons, the most obvious of which is that it can't spur defendants' other arguments the threat was directed at Amyiah's parents and not her. That doesn't quite make sense. And also, you could presumably arrest the parents for if it were illegal, because they're the legal guardians, and so they may absorb some legal responsibility here. That might be a possibility too. We'd have to get into that, but I'm not quite sure that argument fails for that reason, though. Defendant could not even arguably have probable cause to arrest Rich and Angela for disorderly conduct, since the social media post at issue was not from them. Fair enough, but if it's a lawful order and they're refusing, then the charge wouldn't be disorderly conduct. The charge would be obstruction of justice, which it would be in that circumstance. So if they are saying no and they must, then the charge would presumably be obstruction, not rather than the underlying thing. But they'd be guilty of something. Even setting the threshold problem aside, defendant quite clearly does not have probable cause to cite and arrest Amyiah for disorderly conduct, nor was it reasonable for them to think that they did. Again, putting myself in the position of the people at the time. This is what we have to do. We have to look to what they knew at the time, not what we know now. Who knew what and when at the time? So what do we know? We know that the health department conducted a negative test. We know that the information was given to the sheriff's department. Well, through one means or another. I forget exactly how that information came into the possession of the sheriff's department, if they were told directly or whatever, but whatever, it came into the possession of the health department. On the belief of that negative test, they then did these things. And I don't believe it was well known at the time, the success and failure rates of these tests. So given what the sheriff knew at the time, they probably were in a position to reasonably rely on the test and reasonably believe it was false and reasonably believe it might be inducing a panic and reasonably believe blah, 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 blah. Now, whether or not I think that's actually true in the abstract, because I think Amyiah has the right to lie about stuff, but were they in a position to reasonably go the other way, especially on qualified immunity grounds, given what they knew at the time? Probably yes, because we haven't seen anything in here that would contradict that understanding. You know, that we haven't seen, oh, it was understood these tests were bad. It was understood that these tests were unreliable. We haven't seen that argument, which makes me think it doesn't exist. Defendants concede that the post was in no way violent, abusive, indecent, profane, boisterous, or unreasonably loud, but argued her post could still fall within a catch-all for otherwise disorderly conduct tending to cause or provoke a disturbance. And after my previous streams, I have looked into case law on this issue, and I do have to correct myself that, yes, you can get disorderly conduct for written material like this. So it is possible that it was followed to otherwise disorderly conduct. What is the otherwise disorderly conduct? It's causing people to panic. It's causing people to, you know, if it were really not true, it would cause people to panic, cause people to engage in all kinds of things. It would cause a problem in the real world. So, you know, $2 from Bob. Thank you very much. It's appreciated. Yet they have no answer to the Wisconsin Supreme Court holding this disorderly conduct statute may not be applied to protected speech, which is true, but somewhat begs the question. As noted above, they concede the silence that the speech was protected. Interesting try. I don't think it quite works. So they're arguing that the other side has dropped the issue and conceded it. I don't think that quite works. I think it's fair to say that the other side has conceded that in knowledge of now, it is now protected. I think that's fair. But again, we're looking to what it was known at the time, and they definitely argued QI to death. So I think the attorney here is trying to pull a trick, which I don't object to as an attorney. I try to pull tricks all the time, which again is why I can recognize them, at least sometimes, when they're being done. So they're trying to say that the other side has conceded a point, and therefore the court must rule this way. They're being a little bit. They're pulling a trick. They're using language in a slightly clever way, which again is what attorneys do. But I've taken note of it, and no, that's not quite what they did. That's not quite what they conceded. But nice try, but no. Nice try, but no. The facts in a case called Douglas D. further illustrate it was unreasonable for defendants to treat Amyiah's post as disorderly conduct. The speech in that case was much more egregious than Amyiah, an implied threat from a student to decapitate a teacher. Yet the court held that this was protected speech and therefore outside the disorderly conduct statute. Okay. Well, you'd actually have to get into the case, which I don't have in front of me, and the difference of it. But you could presumably differentiate, because Amyiah is making, they say it's an implied threat. So the maybe it's not explicit enough to, because the analysis there would presumably be true threat. So that would be the exception. The speech, we don't apply to true threats. And so the analysis there is, oh, it's not a true threat because it's only an implication or blah, 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 whatever. So the analysis is, in that case, presumably, it's not a true threat, and therefore it's not disorderly conduct. But the claim here is a little bit different. We're not arguing true threat. So the cases are a little in opposite. We're not arguing true threat. We're arguing that this was creating another disturbance under a different statute. So I don't quite think the failure to find that was not disorderly conduct can be read mutus mundus here. I don't think it quite works. Defendants argue the concern in the community about a student from the band trip possibly contacting COVID-19 gave them probable cause for disorderly conduct citation, but they're wrong for at least 3 reasons. First, Wisconsin Supreme Court has explained that disorderly conduct does not cover everything and anything that cause personal discomfort in others, but only those that tend to menace, disrupt, or destroy the public order. Which, once again, with respect to Amyiah's lawyer, given what we know at the time, could the defendants reasonably believe that Amyiah's post was a menace, disruption, or destruction of the public order? A little bit, yes. A truly false claim would be a problem. Runs into boy who cries wolf issues and all kinds of things. So I don't think that case stands for the proposition you want it to stand for. I think it goes the other way. So we also have a U.S. Supreme Court case overturning a disorderly conduct conviction because speech is protected against censorship or punishment, less likely to show clear and present danger of substantial evil that rises far above public inconvenience, annoyance, or unrest. Again, slightly in opposite. The issue there is the lawfulness of the arrest or not, which again goes to the adjudication of something, but we're under a slightly different thing here. Now, the threat of arrest can be thought of parallel, but it's still slightly in opposite. And yeah, I don't think it quite works. Sharing one's scare with COVID-19 online simply does not rise to that level. If it were false, it might. But that, again, it goes exactly into who knew what and when. If it were true, then yes. But if it's false, then no. And what did the cops believe? And the cops were acting on the basis of a medical test, which said no. That they presumably had the ability to rely on at the time. So, yeah. Second, the concern in the community was more directly attributable to COVID-19 itself, to the fact that Amyiah may have actually had it, even though she ultimately tested negative, and the school's failure to notify other parents after the Cohens informed the school rather than Amyiah's post. Finally, contrary to defendant's argument, the video establishes Sergeant Klump did not have probable cause to believe that Amyiah's post was inaccurate when he issued the threat. Yes, he did. He absolutely had probable cause. Probable cause is a fairly low standard. It's more than reasonable suspicion, but it's not preponderance of the evidence. So, did he have probable cause? Yes, of course he did. He had the test from the health authority, which is pretty good authority. Now, he did have some contradictory evidence. He did have some contradictory evidence in the view of the work release form from which he apparently read and saw. So he did have some contradictory evidence. But did he have probable cause? No problem. Did he have preponderance of the evidence? Maybe not. But did he have probable cause? Sure. Probable cause is a fairly low standard, and he had enough objective evidence that would lead a person to that conclusion. For probable cause, sure. The only information defendants had was that Amyiah's test was negative, which again is a pretty big deal because it's coming from what looks like a competent health authority. So it's a pretty big deal. Yet Amyiah's father tried to explain to Sergeant Klump at least 4 times that despite the result, the doctors believed she may have had it. But we're talking about probable cause, not preponderance of the evidence. If we were under preponderance of the evidence, then we'd have a different discussion, but we're not. We're probable cause. Does he have probable cause? No problem. Of course he has probable cause to believe it's false. The health test is pretty good authority. The video captures Sergeant Klump admitting just before he arrested that he didn't know the circumstances Amyiah was in. He has enough. So he cannot claim he had probable cause to believe it's false. Yes, he can. And yes, he did. You're just plain wrong on this one legally. I'm sorry. You're just plain wrong. He absolutely had probable cause. Probable cause is a pretty low standard. I know you don't want to be true, attorneys representing Amyiah, and I appreciate that you're zealously advocating for your client. But no, absolutely not. He absolutely had probable cause to believe it was false. Notwithstanding the explanation of his own ignorance of what the doctors had told Cohens. It doesn't matter. He had enough for probable cause. It was more than enough for probable cause. Probable cause is a pretty low standard. It's not nothing, but it's pretty low. It's pretty, yeah. And a test from a competent health authority is more than enough to make probable cause. So yes, we have not seen any discussion at all so far about qualified immunity, have we? uh-oh, we're in trouble. We're in trouble. We haven't seen any discussion about qualified immunity. We've seen why it was protected by the First Amendment. We've got half of the QI analysis. It was protected by the First Amendment. I believe you. It was protected by the First Amendment. But yeah, okay. At summary judgment, a plaintiff is entitled to permanent injunction if they've shown success, as opposed to likelihood of success on the merits. Irreparable harm, the benefit of gaining the injunction outweighs, and public interest will not be harmed by the request. For reasons explained below, the video shows a straightforward First Amendment violation. Sergeant Klump demanded that Amyiah remove her social media posts and then threatened to issue disorderly conduct. The threat has created an ongoing irreparable harm. The Supreme Court has often noticed that a realistic threat of arrest is enough to chill First Amendment rights. Amyiah would like to speak further about her scare with COVID-19 in at least 3 different ways. First and most importantly, Amyiah would like to respond to and correct the director's statements to her peers, their families, and their teachers that her prior posts were lies and foolish means to get attention. Second, we'd like to continue to share her friends and family with the experience. Third, we'd like to repost the Instagram post that made her remove. Amyiah fears that if she spoke further about these experiences, another deputy would show up at her home and follow through on her prior threats, which is a little bit undermined by the fact this lawsuit exists and presumably sheriffs have not shown up and demand that be taken down. A little bit undermined. Since she removed her post, she's not stated any further about her experience. Defendant continued refusal to acknowledge either the violation was protected has only an exasperation or a chilling effect. Before this case, Cohoon sent a letter asking them to confirm that they may freely exercise their First Amendment rights, including reposting that they were told to remove and you not state or file them of jail, arrest, or jail them, or threaten any of the above for exercising their rights. Sergeant Conrath then responded that speech was not protected by First Amendment, but was the equivalent of screaming fire in a crowded theater, which, again, goes specifically to the falsity of it. If it's true, yes, you can. If it's false, no, you can't, because of the panic. But if it's true, you can. But what was known to the sheriff? It would be the rough equivalent in this analogy, although obviously the analogy leaves a little bit to be desired, but bear with me. It would be the rough equivalent in this analogy of a person screaming fire in a crowded theater, and there being a fire marshal who happens to be there, who stands up and says, no, there's not. And the police says, I'm going to rely on the fire marshal who says, no, they're not, and arrest you, even though there is, in fact, a fire. I know the analogy left a little bit to be desired because fires spread pretty fast, and so there's not really the time element that would, but if we can suspend the time frame issues, if we believe that a person screamed fire in a crowded theater, everyone starts panicking. A fire inspector goes in and says there was no fire here, and then they arrest you. But it turns out there was a fire, and the fire inspector just sucks at their job. But the police had a reason to believe the fire inspector was correct, even though they couldn't, smell the smoke and see the burning embers. Everything looks fine to me. The police can reasonably rely on that, even if it later turns out to be, not true. So that would be the rough equivalent of this analogy. So our fire marshal in this analogy is the health authority who says, no, there's no fire here, and there's no disease here, and then relying on it, even though that turns out later not to be true. So yeah, it goes into the relevant knowledge of the relevant people. The speech was protected because it was, but the police are protected because they relied on something that gave them probable cause. So yeah. That would be the equivalent, I suppose, in this analogy. All Sheriff Conrath offered was a letter stating the department's investigation is complete, but simply confirmed they complied with the demands, which of course they already knew. Even now, before the court, Sheriff Conrath still openly refuses to acknowledge that the post was protected speech, or represent she will not be cited for speech going forward. Which presumably he's doing that at least in part because his attorneys told him to keep his mouth shut, which he should do. While, on the other hand, Sheriff Conrath claims that he never directed Sergeant Klump to immediately arrest or cite for conduct, he admits that he considered and directed a course of action, and continued to assert that speech gave him probable cause to arrest. At the time, probably yes. The prior threat, combined with the refusal to disallow, combined with instances that the threat was lawfully, provides a sufficient chilling effect to warrant an injunction. But even if the court believes an injunction is not warranted, a declaratory judgment certainly is. Which I would agree with that. Your injunction is not happening. But a declaratory judgment, if I were a judge, I will give you a consolation prize of a declaratory judgment. Yes. So I would give you I won't give you the injunction, But I would give you the declaratory judgment to say, yes, it was lawful at the time. I'm still going to throw your case out of jail, but I'll give you the declaratory relief so you can feel better going forward. So I'll give you something. But QI, okay, they're about to get into the QI, it looks like. So they're about to get into this QI analysis. If we can beat QI so I don't have to rule against Amyiah, that would be great. But I will definitely give you the declaratory relief. Even if this court believes the injunction is not warranted, a declaratory relief certainly is. The Supreme Court has explained a First Amendment case premised on a threat of arrest for handbilling. The express purpose of the Federal Declaratory Judgment Act was to provide a mild alternative to injunction, and irreparable injury is not required. All is required is a genuine threat, for reasons just explained as present. Thus, the court should issue a declaratory relief. Yes, I will give you that. Judge Blackleaf will give you declaratory relief. I'll give you that. Let's figure out if I can give you anything else. Defendants argue they're entitled to qualified immunity, which is a pretty good argument, but their main arguments here track the merits arguments and fail for similar reasons. I really hope you have more than that. Defendants do not dispute that, as a matter of clearly established law, they may not threaten or arrest for protected speech. Nor do defendants dispute that Sergeant Clump threatened to arrest people if they did not remove the post. Instead, they argued that they're entitled to qualified immunity because the threat was not issued in his presence by their parents, which is material, and also... Is that exactly what they argued? I guess I could go back to... Well, that's their declaration, right? Not the motion. So I don't remember them quite arguing that in the motion. That might be what's in their declaration, but I don't remember that being in the motion. The motion was all about QI, and we read it, and we remember me being very sad as I read it. So I don't quite remember that. That's beside the point. It's a little bit not beside the point. It's a little bit not beside the point. There's no question Amyiah became aware of the threat while Sergeant Clump was at her doorstep, in front of her, while Sergeant Clump was discussing it. It was more than enough to chill the speech of any 16-year-old, which is exactly why her parents being there is material, because they're exactly the ones who are supposed to stand up for her rights as her guardian. The very fact that they are there is very, very, very material. Yes, no 16-year-old would refuse the police. That's exactly why the parents being there is so material. The parents are her legal guardian, and they're the ones who can enforce it on her behalf if they are so inclined. Or not. So yes, the parents being there is pretty important. It did cause Amyiah to censor her. She deleted a second post out of fear he'd return and follow through on the threat. Okay. And even setting aside the threat completely, has long been established, the government may not censor speech on its content. Generally speaking, true, but not quite what we're going here. Sergeant Clump came home and demanded, not requested, that the kid contain social media posts. That's alone as a First Amendment violation. No, I'm sorry. I wish it was. I really wish it was, but no. Because the content of message is many times, the very fact you're shouting fire in the theater is the content of the message. You could presumably shout other things without it being a problem. It might be a problem for other reasons, but not disorderly conduct reasons. Or might be disorderly conduct, but for other reasons. But anyways, you could shout like popcorn, and people would be annoyed, but it wouldn't create the same thing. So the content of the speech, when the speech is part and parcel to the criminal conduct, you don't get protection for that. So the very crime is creating the disruption. The speech being used you don't get protection for the speech. If you did, then like every conspiracy you wouldn't be allowed to have conspiracies. Conspiracies are just agreements, which agreements are words. So yes, words can create criminal liability based on the content of those words. I'd like to let us go to the theater. Let us go to the bank together is legal. Let us go to the bank together and rob it. Not so much. The content of the words is definitely something that's creating a problem. Yeah. Perhaps recognizing the logical flaw in the main argument, defendants then assert somewhat half-heartedly that it's not clearly established the posts were protected by the First Amendment. Yet defendants do not identify ambiguity that make it reasonable for them to believe it was not protected. They note the First Amendment does not protect obscenity, defamatory, fraud, incitement, and speech integral to criminal conduct, which this would fall into that category, presumably. Speech integral to criminal conduct. That would be your standard run-of-the-mill public disorder kind of charge. The speech is integral to creating the disorder, yes. But they do not claim that speech even arguably falls in this category. Instead, they confusingly invoke the health department's authority to control communicable diseases, which obviously has nothing to do with defendant's authority. It has a lot to do with their belief the First Amendment or policing social media, which is clearly not. For conspiracy, you do need an overt act to establish the conspiracy. Thank you, Matt. Thank you, Matt, for being pedantic and also making me look bad by correcting me. That's great, Matt. Thanks. That's genius work. Yes, Matt is correct. Way to go, Matt. Yes. To have a conspiracy, you need both an agreement and an overt act towards the conspiracy. Matt is correct. Merely saying, let us go to the bank and rob it, does not form a conspiracy. He is correct. You would need to take an overt act. Way to go, Matt. Good work. Way to go. That's okay. We like rousing each other. It's part of our service that we provide here at Uncivil Law. The Matt and Blackleaf rouse each other portion of the thing. They also cite the unprecedented nature of the example, as though world First Amendment principles suddenly become unclear. They have a point. I don't want them to have a point, but they do. The argument as accepted would not only turn the clear established requirement, also give law authority clear carte blanche to do whatever they want. This cannot be right. Well, it wouldn't give them quite carte blanche. That's a little unfair. No, it wouldn't give them carte blanche. And I've tried to make this point in various videos to varying degrees when I've been talking about the various regulations that are in place because of this situation. A lot of people have said that this is a violation or suspension of the constitutional rights. And at least from my perspective as a lawyer, and I'm speaking just for me, at least from my perspective, it's not an abrogation of the constitutional rights, because the strictest level of review we typically have is what we call strict scrutiny. To have strict scrutiny, you have to have a compelling governmental interest, and it has to be the least restrictive means in the view of that compelling governmental interest. And the facts support that right now, or not right now to be proper, but they supported it, say, 2 months ago. And they're increasingly unable to support it, which is increasingly why you see states beginning to roll it back and put in different things, and courts starting to get interested and involved. Because the facts, as they've changed, no longer support the strict scrutiny analysis. But in the first instance, did they have a compelling governmental interest? Yes. Protection of public health is pretty high a governmental interest, and they had all the reason to believe, in the view of the uncertainty, that the threat profile was high. Were some of the measures taken not the least restrictive means? Well, we've seen some of the courts strike some of that stuff down. For example, not being allowed to attend church services in a car. What does that have to do with anything? So we have seen where this has not been the least restrictive means. But, generally stay away from each other, generally don't allow people, must wear masks, blah, 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 blah. Generally legal? Yeah, probably. At least 2 months ago it was. Now, that information changes on an ongoing basis because it's a fact-based analysis. Like all court analysis is a fact-based analysis. So the strict scrutiny analysis, and I said this at the time. I said very deliberately when I said it before, it was legal then, but might not be legal in the future because the analysis is changing. It's ever changing. And so the strict scrutiny analysis is beginning to fade away because the facts are no longer supporting it to the same degree. So yes, I think that the situation does provide an additional impetus. Again, at the time, we're putting ourselves in the position of what people knew at the time, what they were doing. And the uncertainty profile at the time. The uncertainty profile about the disease, because Amyiah's case was relatively early, from what I understand, in all this situation, right? She was in Florida March 15th, and then shortly thereafter, at the end of March, she's getting sick. So she's relatively early in all this. So she's in the position of people being in a position of uncertainty and people not knowing what this is or how much it spreads or whatever. So people were in a position of lack of knowledge. And in lack of knowledge, they want the increased safety. No, the strict scrutiny analysis gives that to them. So at the time, was the sheriff acting reasonably based on what they knew? Probably. And we so far have vague general aspirations from our friends over at Amyiah's lawyers, but it's not going well. It's not going well. The closest thing they come to an ambiguity would warrant a qualified immunity is a single sentence suggesting it was reasonable for defendants to believe, even if ultimately incorrect, that falsely claiming to have COVID-19 is the modern-day equivalent to shouting fire in a theater 100 years ago. The fire in a theater example comes from Schneck, which is an incitement case. Obviously not applicable here. It's closer than not. It's not quite incitement, but it's closer than not. it's creating a public panic that first articulated the now defunct clear and present danger test. See Brandenburger of Ohio, with replacing that with an incitement to immediate lawless action. Also not relevant here. The court subsequently explained that the exception requires imminent harm, a clear and present danger of substantial evil that rises far above annoyance or unrest. The defendants could not have relied on the fire of the year analogy because even if not, it did not create an imminent risk of harm to anyone. Yeah, but the statute is a little broader than that. Imminent harm is one of the bases, but not the only basis. And the Supreme Court of Wisconsin has said one of the bases is civil unrest and civil disorder and whatever else they said. Or was it the U.S. Supreme Court who said that? Either way, I think they're in that. I think they can fall into that ballpark at the time. And so far, all we have is very generalized things, generalized statements. We don't have anything enough to get to QI. So, yeah. Defendant's fire in a theater is also an act because one can yell fire that's actually burning. Yes, but again, this goes to what I was saying earlier. It goes to who, know, what, and when. Yes, you can yell if it's actually burning. Yes, it's protected speech. But if the police arrest you on the belief that it's not, particularly in light of the equivalent of a fire marshal telling the police, no, there was no fire here, and they arrest you, and then it turns out, oh, yes, there was a fire, and the fire marshal sucks, then she was protected in what she was saying, but the police are also protected in the way they were doing things because of what they knew at the time. When Sergeant Clump issued the threat, he had no reason to believe it was untrue. Yes, he did. Yes, he did. He had probable cause to believe it's untrue. He had a report from the health authority. That's pretty good authority, man. These papers are contraindicating. But could you in that position reasonably believe the health authorities writing these papers are wrong? Yeah, of course. Some random doctor wrote down COVID, but the health department tells me the test is no. The health department test seems more reliable. Who knows why the doctor wrote that? Maybe they just wrote it down because they wanted to write down something. I don't know. But the health authority looks pretty good. To a reasonable officer at the time, given what they know? Yeah, I think so. Rick explained to Clump at least 4 times the doctors believed him to have COVID, even though he tested negative, fair enough, and didn't know the circumstances, fair enough. But in balance, he's still where he needs to be for probable cause, because probable cause is a pretty low standard. Regardless, defendants concede it's clearly established that falsity alone is insufficient for them to censor speech. Generally true. Cite New York Times versus Sullivan that false speech is correct. Yes, generally yes, but we are in a more specific environment. It's not just that it's merely false. It's false in a way that is inducing a panic, public uproar, blah, 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 people calling the schools, people panicking, people taking all kinds of things, and a lot of uncertainty, all the things, and the government thinks it's false and creating a panic. Do they have probable cause to believe it's disorderly conduct? Probably. I think so. Yeah, given what we now know, especially now that I've read the Wisconsin Supreme Court case that tells me that stuff in writing can also be disorderly conduct, which was an assumption I went the other way before in previous analysis. So if you're wondering why my analysis is a little bit different, it's because I've read more and become more educated. I've become a better lawyer since we last spoke. I'm always improving. So I read the Wisconsin Supreme Court case that says, oh, the stuff in writing can also be disorderly conduct. Oh, okay. Under certain circumstances. And I think they're parallel. And there's nothing clearly established in terms of the specific situation. It's too idiosyncratic. So, no. Absolutely not. Even if qualified immunity applies to an individual capacity, Konoth is still responsible under Monell as his capacity as sheriff. Can you get to Monell if you don't have an underlying violation? I don't know. I've never read a case like that. I've never read a case where there wasn't an underlying liability, but they still read Monell. So I don't know. If you don't find the underlying thing, can you get to Monell? Maybe we're going to both learn some new law together. Qualified immunity does not express response to Monell claims against local government units. Okay. That doesn't seem right. They cite 2 U.S. Supreme Court cases that say that says that. But that doesn't seem right. And they haven't quoted like language from those cases. So I'm not sure what those cases say. But it doesn't seem right. But I'll read on. Supreme Court has squarely held that municipal liability may be imposed for a single decision by a municipal policymaker under appropriate circumstances. Sure, I think that's true. They gave the example of one appropriate circumstance. A sheriff's decision with respect to law enforcement over the sheriff as the official policymaker would give rise to liability. In light of PEMBAR, the Seventh Circuit have explained that Monell claim may be premised on an allegation a constitutional injury was caused by a person with final-making authority, and found the county sheriffs to be final decision-making for the purposes of Monell. Sheriff Conrath does not dispute he's the final-making authority, which of course he can't. He's the sheriff's department. You know he's the final authority because it's called the sheriff's department and he's the sheriff. So that's how you know that. Defendants argue that something more than Sheriff Conrath's participation is required, quoting the language for a proposition: the fact that a particular official, even a policymaking official, has discretion, does not without more create a municipal liability. But PEMBAR explains what it meant by more in the next sentence. The official must be responsible for establishing the policy with respecting such activity before the municipality may be held liable. In other words, the court was simply drawing a line to discretion on one hand and final authority on the other. In a footnote to this sentence, the Supreme Court gave an example: sheriff's decisions which would give rise to municipal liability. Likewise, in Barkow, the Seventh Circuit found that allegations that a county sheriff participated in an unconstitutional seizure were sufficient for liability on Monell. QI does not apply to the law enforcement with respect to Monell. I don't know. I don't know that we've ever seen a case like that before. We've covered quite a few QI cases, but I don't know that we've ever seen a case quite like that before. We've definitely seen, I'm not quite sure that is right. Sheriff Conrad's only other argument is that he did not. We might have to go read those Supreme Court cases, or at least read the footnotes, or read the cliff notes of it before we render our decision. So, but at the end of the stream, when we get to the end, we may have to come back here and we may have to at least skim those decisions to figure out what they say, to figure out if he's right or not, because it would go to impact our analysis for the sheriff's liability, maybe. So we might have to go read those cases. Sheriff Conrad's only other argument is he did not direct Klump to immediately arrest, but instead called merely to request that she post it voluntarily. This contradiction is explained by what Klump told the Cohens at home: if she doesn't come down, he's directed me. Which isn't quite right. What he told them and what is true are two different things. He might have been saying something that wasn't true. He might have been bluffing, which will go to his liability, but not his superiors. So, yeah, the fact that he said that doesn't mean it's true. Maybe he's lying. The police do have the ability to lie, as we know from too many cases. They do have the ability to lie. So maybe it was a lie when he said that. Maybe they can't lie, on the record, and they've said that, they said, and the stuff said that they needed to get that stuff back. So maybe it was a bluster. Maybe he would have, maybe if it had gone another way, he would have radioed it in, and then the sheriff would have said to arrest, and then they would have arrested or whatever. But it goes to his liability, not necessarily the sheriff's liability. It's also contradicted by the incident report, which Conrath reviewed and approved. The report stated that Conrath told Sergeant Klump to respond to the incident and have it removed. That's true, but it doesn't say, and if not, then arrest. Right? That's partially what's going on here. The incident report further notes that Klump advised Richard not wanting to take it down, there'd be the possibility of an arrest. Sheriff Conrath reviewed the report and told him in an email that it was accurate and to the point. If Sheriff Klump's threat of arrest were a true deviation, the Sheriff Conrath would have noted this after reviewing it. Not quite what they're arguing. A little bit off point. Sheriff Conrath's current position in litigation is also inconsistent with his actions before the lawsuit was filed. As noted above, they sent a letter explaining it and asked the sheriff to do this. If Sheriff Conrath actually intended to communicate only voluntarily request, he would have said so. Instead, what he offered, the speech, was 2020 version of shouting a crowd theater, which, again, when you look into when these emails were being sent and when they were being received, that goes, I don't think he had any knowledge at that point that would go the other way or would be enough to undermine probable cause. So I'm not finding these statements from these emails particularly damning. Regardless, the sheriff admits he discussed disorderly conduct before sending it home, so he cannot evade responsibility. The president was an implied threat. We may have to get into the Supreme Court cases on those two things and figure out whether or not QI applies to Monell or not. And it seems like it would have to. How can QI not apply to a Monell claim? That's blowing my mind a little bit. So we might have to read the Supreme Court cases and figure out whether or not it actually says those things. Because if so, I'm going to have to rework the analysis for the sheriff's liability in my head. As plaintiff explained in her motion for a preliminary injunction in the First Amendment case, the analysis often begins and ends with the merits, because the loss of First Amendment protections constitutes irreparable injury, and injunctions are always in the public interest. The defendants do not dispute this framework, but argue a preliminary injunction is unwarranted because they've not exceeded. For the reasons explained above, that's incorrect. A preliminary injunction is not needed because we can just render it on the merits. A preliminary injunction at this point is just not called for in any such circumstance. You'd be looking for a permanent injunction at this point because we're at the end of the case. We're at the end of the case because both sides have moved for summary judgment. So at this point, with both sides moved for summary judgment, we're at the end of the case. So now would be a time we'd be talking about permanent injunctions. You're not going to get one of those either. But preliminary injunction is kind of mooted at this point. The defendant's only other response to the request is not specific enough, which is a fair point. To the contrary, it's narrow, prohibiting defendants from citing for disorderly conduct, arresting, or threatening them for any future speech about the scare with COVID-19. Again, it is a little bit broad. Like anything relating to COVID-19, it can't be quite that broad. So it would be anything COVID-19 that is true, I suppose, would be the better way. It is a little broad the way it's written. Yeah, can't give him that. Can't give you that. The defense objection is that the injunction seeks to prohibit an action that did not have an action in the past, which is not how injunctions work. Injunctions go forward. So who cares? It's surprising the evidence to the contrary. The defendant also objects to the injunction applies to the parents who are not named parties. But, of course, a threat taken to one's parents is quite coercive, even more than enough to violate her First Amendment rights. Yeah. Finally, defendants complain the requested injunction covers hypothetical future speech and is therefore vague. When it comes to injunctions, they have a point. Plaintiff limited her request to her scare about COVID-19, which, again, I would have to be narrowed even further, which would not be difficult to apply. But even if this court agrees there's some ambiguity, it can give you the injunction. Judge Blackleaf would think about the injunction, but probably not. Judge Blackleaf would give you the declaratory relief, but it would not probably give you the injunctive relief. So, because we can declare what is true and declare your rights to be true going forward, but we don't need to do an injunction. So I'll give you the declaratory relief, but not the injunctive relief. And you're losing on your underlying things because your QI argument is horrible. So your QI argument for the deputy is absolutely horrible and atrocious. So the deputy is definitely winning this on QI. So that, I think, is he had more than enough to believe probable cause, more than enough evidence at the time, and but COVID though is also getting them additional latitude. So Judge Blackleaf, if he were writing this opinion, would unfortunately disappoint you all, including myself, and he would rule against Amyiah on the underlying issue. He'd also rule against him on the preliminary injunction because it's kind of mooted. Rule against him on the permanent injunction because law enforcement authority. But I'll give you the declaratory relief, so that'll be something. So I don't need the injunctions. I'll give you declaratory relief. So yeah, okay. So that's where we're sitting on that. Okay, great. Let's read some stuff, more stuff. We've got response to proposed findings of fact. So we've got proposed responses to findings of fact. So we can now look at the two party sides, and we can look at the findings of fact, and we can adjudicate what the facts are formally as we're rendering our continuing legal opinion. So let's look at the facts and what we think the facts are, and let's see if what Judge Blackleaf, I'm now going to tell you what the facts are, because I'm the trier of fact, because this is a bench trial. I get to do that. Yay. So I'm going to tell you what the facts are. I'm not going to declare these are facts. Awesome. Okay, so we're responding to the sheriff's proposed responses. So we are going to assume, we're going to say what the facts are, and if they're disputed, we'll adjudicate it. All right. So here are the facts. In 2020, they took 100 trips to Florida. Undisputed, accepted. While they were in classmates, they did various things that Florida was closing businesses. No dispute, accepted. Before the trip, the director of the health authority met with the school superintendent to discuss the health issues in taking it, including states were facing community responses or no travel recommendations. Undisputed. Okay, so the health authority met with the director to discuss issues with the trips. Okay, fine. Undisputed. Accepted. The school district decided to proceed with this trip. Accepted. The local health authorities have close working relationship with the Bureau of Communicable Diseases and Lab of Hygiene. Undisputed. Accepted. It is the state's protocol that has notified designates of a class 1 disease. Yep, we'll accept that. COVID is a class 1 disease, meaning that it's reported to a local health authority. So there's your answer to HIPAA, by the way. Yes, it's a category 1 disease, so it's being reported to the health authority. We accept that. The state authorities have issued guidelines to local authorities. No dispute. The most widely tested for this test is the PCR test, which stands for polymerase chain reaction. Fine. State officials from the Bureau of Communicable Disease and Wisconsin State have stated to local departments that the test yields a high degree of accuracy. Undisputed, except to clarify the test procedures, the test produces both false positive and false negatives. Yes, type 1 errors. And regardless of the accuracy of the test Amyiah was given contained a disclaimer: test negative results should not be used as a sole basis for managerial decisions and do not preclude this infection. Okay. I accept your proposal as modified. Yes, it's a highly accurate test to produce both false positive and false negatives, or at least this was communicated. The state officials stated it. So that was what they believed. They believed it was highly accurate. Whether or not it is highly accurate is, again, beyond the point. What did they believe at the time? They believed it was highly accurate. I take note of that, and that's going to be a problem. It produces both false positives and false negatives. Of course it does. But it's still highly accurate. Enough for probable cause, for sure. For sure. I would think. Recent data from this test shows that some tests, meaning that 9% of the tests, okay, recent tests shows that of the tests, 9% of the tests return as positive. Okay, fine. Failure of the tests are generally applicable to 3 circumstances: using improper testing, storage, or testing outside the infectious period. Undisputed. Yes, there's a lot of reasons this test can go wrong. An improper testing method means a biological sample taken was insufficient. Sure. An insufficient sample could be due to unsuccessful swab. Sure. The swab can be physically uncomfortable. Yes, I would imagine can be. Regardless of the reason why a sample is insufficient sample yields no result, meaning neither positive nor negative is obtained. Okay. Retesting a sufficient sample is the only way a test will yield a positive or negative. All right, fine. The state notifies local authorities if the testing sample is inadequate or when a sample is sufficient, the positive or negative. Okay. Improper storage of shipping methods means the collected sample was not stored in the correct medium, was not kept adequately cool, or not received. Yes, there's a lot of reasons the test might go wrong. In cases of improper storage, the lab indicates it was not tested. Sure. The testing period is during the infectious period. Undisputed. When assistants test positive, they're notified through a system. Yes. Based upon data to date, which I presume means at the time this affidavit was written, which is a couple weeks ago at this point, a person becomes infectious about 48 hours before they develop symptoms and remains symptom-free for past 72 hours without a medication. Sure. If a person tests COVID-19, they're shedding the virus regardless of medical treatment. They're shedding the virus? That's a weird phrasing. Shedding the virus? Spreading the virus, presumably, but they went with shedding. They're shedding the virus. It is undisputed that the virus is shedded, like dead skin, I guess. It's shedded. All right. The data and infectious period criteria means a person will test positive for the virus with a significant degree of certainty within the period, including when they're symptomatic. Response: disputed. All right. So let's read this because it's disputed, and let's adjudicate what we think the fact is, or at least what I think the fact is. This data and infectious period criteria means a person will test positive for the virus with significant degree of certainty within the infectious period, including when they're symptomatic. Okay, Disputed. The test provides both false negatives and false negatives. True. The test given to Amyiah was contained with a state disclaimer. Fine. And some of the health professionals believe as many as 1 in 3 patients who are infected are nevertheless giving a negative test result. Yes, but this was April the 2nd, and did the police know about that at the time? Even if this was after April 2nd, which I forget exactly when this occurred, it might not necessarily be well understood at the time. So I accept your facts as modified, with the additional stipulation that I am not clear that I'm going to be reading this thing from the Wall Street Journal onto the police. It's not clear that it's timely, and even if it is, it's not clear that the police necessarily read the Wall Street Journal or that it would be well understood at the time. If a person tests outside the period, they're asymptomatic. Undisputed. If a person is tested, confirmation is unlikely. Undisputed. Diagnosing the virus without testing is not recommended because the symptoms have changed over a month and a half. Undisputed. Original symptoms include fever, cough, and shortness. Undisputed. The original symptoms were also characteristics of common colds and other diseases. Undisputed. Yes. This is also incidentally why when people say this is like the flu and people say no, it's not, I get a little frustrated, because like the flu is providing an analogy. It is the flu is a metaphor. This is the difference between metaphor and analogy. Yes, COVID-19 is like the flu. It's not exactly the flu. That's why I didn't say it is the flu. But it is like the flu. It has similar symptoms. It has similar disease vectors. It has similar issues. They are similar. There are some notable differences, but they're similar. It is like the flu. It is different from the flu in many material respects, and it's like the flu in many material respects. And as Tater Raider also points out, that the Wall Street Journal report should be taken as true, which is a very, very fair point by Tater Raider. Very fair point, because this would, my analysis would suggest that the police should believe the media, which is definitely not a conclusion I'm prepared to draw. So very fair point. So yes, the police, whether or not they knew about it is irrelevant, because why would they believe it? Because it was reported in a newspaper. Ha ha ha. Very good point. Similarities of the disease include gastrointestinal symptoms like nausea, vomiting, and diarrhea, as well as loss of taste, smell, and other symptoms. These expanded symptoms are also found in cases of food poisoning, allergies, or the common cold. Accordingly, anyone experiencing the symptoms could be incorrectly diagnosed without proper testing. Fair. The state guidelines do not require investigation by a local health authority without confirmed test. While a citizen tests positive, the Citizens Health Department is notified of that result. The Wisconsin Electronic Disease Surveillance System. On March 25th, Marquette County Public Health nurse Davy received an email from the Westfield school nurse, Nicole, stating that the school district had learned in the past week from a mother on the Marquette school that a daughter had contracted while on the trip, and a student was now in the hospital and may be placed on a respirator. So the school nurse, presumably learned this from the school principal, is contacting the state health authority to let them know. Cool. In this email, the nurse asked the nurse if there are any confirmed cases in the county. The nurse called the nurse and advised her department had not received any notice through the system, and there were no confirmed cases at that time. Yeah. Nevertheless, the nurse requested contact information so she could reach out to the family, ask how the student was doing, and offer assistance. Okay. This was the Health County standard protocol regarding potential threats. Nurse Davy called the mother later on that day, stayed in the conversation, and taken the emergency room. Nurse Davy then called the emergency room and spoke with another nurse named Lindsay, who confirmed that they were in the emergency room and most likely was going to get tested and transferred. During the morning of March the 26th, the Marquette County Health Department received notification through the state system that Amyiah had been tested and reported negative. Nurse Davy then asked Nurse Worlett that there were still no confirmed cases. Later that same day, the Westfield School District Superintendent, Robert Miker, contacted the nurse, advising of a social media post, stating that she had the disease and asked whether there were any confirmed cases. The nurse advised them that there were no confirmed cases. This all sounds like the government acting fairly reasonably. The government is acting fairly reasonably on the basis of information they had at the time. So, yeah, your QI is not going to go. It's not going to go well. No, there's no way. This is all undisputed. We are now making findings of fact. These are undisputed. This is, in fact, what occurred. Both sides agree it's what occurred. This is, in fact, what occurred. The government has lots of information that suggests the answer is what they say it is. So, The emergency operations system is a system implemented to coordinate response. Leading up to the trip, the county health department received calls from concerned citizens who were supposed to go on the trip and other community members. After the post, the health department received phone calls regarding this. Marquette County has a population of 15,200. The county's health department has 8 employees, all of whom had to devote most of their tasks to COVID, including policymaking, documentation, tracking data, blah, 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 and a whole bunch of other stuff. I'm sure they have. I believe all that. That's fine. Okay, so now we have something disputed, so now we'll have to adjudicate something again. As a result of the concern created by the claim that she had tested positive, health department's resources were shifted away from other day-to-day tasks and other public health issues in responding to these numerous calls. Okay, disputed in part. Amyiah's post did not claim that she had tested positive for COVID-19. It stated that she had beat the coronavirus. Fair. The doctors I accept that as true. The doctors told Amyiah that her statements may have still had it notwithstanding. I accept that as true. The test results say that it may not be reliable. I accept that as true. Also dispute that the shift in resources was primarily attributable to post rather than the pandemic itself to the fact that Amyiah may have had disease, even though she ultimately tested negative. No finding of fact. I don't know that I care. There's no finding of fact. I don't care. Okay, yeah, no particular finding of fact. I don't care. The health department, including the nurse, had received telephone calls from other parents and concerned citizens regarding the social media posts. Sure. Health department's officials explain the concerns there are no confirmed cases and try to alleviate the fear. Undisputed. However, defendants' attempt to alleviate the concerns does not appear to be able to keep pace with this growing concern. Response. Dispute defendants had evidence of growing disturbance and concern within the community. No, I'm going to rule against you on that one. Your evidence appears to be that people were making calls to the principal and people were making calls to various health authorities. So I think you had enough. The defense had enough that there was a rising concern within the community. So yeah, I'm going to rule against you on that one. The defense did have enough. The health department was also made aware by the nurse and the school district having received numerous calls from the parents regarding the post, expressing increased concern. Undisputed that the school had received some calls. Dispute that the defendant had showed significant concern in the community. Some calls is enough for a significant concern because the nature of the thing is significant. The disease itself is significant. So the few calls, does it rise to significant? Yeah, for me. So I'm going to roll against you on that one. Director Sophia discussed with the health department the option of contacting the sheriff's department to request assistance in dealing with the increased unreasonable fear in the community. Dispute the evidence that showed an increased fear. I'm ruling against you. So we're disputing that, but we'll learn all the more reasons why there is. After learning of the calls, Director Sophia contacted them to forewarn them there appeared to be increased concerns. So we're not disputing the call occurred. We're just disputing that it shows what it needs to show. The call did occur. It does show what it needs to show. The director contacted and forewarned them to appear to be there increased cases. So the call occurred. They were forewarned. Sheriff Conrath and Director Sophia discussed possible options for responding, disputed that they showed escalating concern. You're there. As part of the conversation about unfolding events, Sheriff Conrath and Director discussed a nearby community response to a citizen's false claim of having tested positive. Undisputed. The incident occurred in Lodi, a neighboring county in Columbia County. The Lodi citizen posted that she was diagnosed, even though he had not, which led other citizens to contact the threat, all because of alleged fear. Undisputed. So they were aware of other purported false negatives. Again, we're looking at the time on what they knew. The Lodi Police Department has recommended that the citizen be charged with disorderly conduct. Undisputed. As the director of the authority, Sophia's biggest concern has been maximizing the health department's awareness to respond to the virus. I have no doubt that's true. False reporting like COVID-19, like the social media posts, cause unnecessary disturbance. Response: dispute the characterization of the post as false. I agree with you. It was not false. The doctors told Cohoon that she may have had it notwithstanding the test results. The test itself says negative. Also dispute the characterization was unnecessary. Or primary attributable to Amyiah's post rather than the pandemic itself. No, I'm not going to give you that one. The concerns that seem to be operable here do seem to be fairly traceable to Amyiah's post. It seems to be people who are fellow parents, fellow members of the school. They're the ones making the post. So it does seem fairly attributable to Amyiah's post. The concerns we're particularly concerned about. So I'm going to rule against you on that one. And the school's failure to notify that they may have had COVID. And no, I'm going to rule against you on that one too. Amyiah's post was true. Amyiah had every reason to believe it was true. It seems to be in fact true, but that is not where the things stop. Amyiah's speech was protected, but the county didn't know that. After careful consideration, discussions, and the director determined that contacting the sheriff's office might be an effort to present accurate information. A positive test would have required contacting each of the people. A positive test would have required them to advise them to be quarantined. A positive test would have required them to check in with each person. A positive test would have required them to ensure those who are reporting for symptoms be referred. If symptoms or tests occurred, each person who tested positive would have been intervened for contact tracing. In order to respond to a diagnosis, the county began to plan for contact tracing. New staff brought in to respond it would have been trained on confidentiality and screening. Increased civil unrest in the community about... Okay. So this is a little bit interesting, maybe. Increased civil unrest in the community about false positive tests added to significant strain on the health department in effort. Response. Dispute the implication of strain on resources was primarily attributable to Amyiah's post, rather than pandemic, to the fact that Amyiah may have had, even though she ultimately tested negative, and the school's failure to notify. There was some increased strain on resources that is primarily attributable to the post, and more than enough to create an interest of the government in reducing them. So I don't know if I would go... There is... This is being phrased in a way that is a little bit disingenuous, which is fine because it's an attorney arguing. Not all the strain on resources is primarily attributable. That's for sure true. But the ones that we're concerned about in this case seem to be. So the strain on resources that are material are primarily attributable, it seems to me. So I rule against you on that one. To the fact that she may have had it, even though she ultimately tested negative and the school's failure to notify. No. Sorry, no. Staff resources were diverted to responding to community concerns about this post. Dispute any strain of resources was primarily attributable. The ones we're concerned about are. These diverted resources hinder the ability to respond. The ones we're concerned about are. Around 5:30 on March 27th, Nurse Davis received a telephone call from a school nurse and learned the parents of the school continued to call the school district regarding the post. People are concerned. Nurse emailed Nurse a copy of the latest social media post. Stated she's finally being home after being hospitalized for a day. She's still on breathing treatment, but she'd been the virus. Stay home and stay safe. Undisputed. The posting forwarded by the nurse included the photograph of her in her hospital gown on her hospital bed, which incidentally is the thumbnail of these posts and will be the thumbnail of this post again when I change it back after I'm done. Further in communication, they called the sheriffs and asked them if they'd follow up regarding the social media posts. The nurse told the sheriff the county had not had any confirmed cases yet to date, yet Amyiah was still posting she had the virus and being treated for it, which was causing a disturbance, including unfounded panic and fear. Yep. Yes. That's a problem. And the nurse had every reason to believe that because of the test, which, again, given what they knew at the time, which is what we're talking about, was enough to rely on. So response. Dispute the characterization of the post as false. It is not, in fact, false. I agree. The doctors told Amyiah that she may have the disease, notwithstanding the negative test result. I agree to that. That is true. The test results itself say negative results, blah, blah, blah. Agree. Also dispute the implication was primarily attributable. The ones we care about are. So, yeah. It was true, but they didn't know it was true. Nurse Davis's intent in requesting a follow-up was hopefully to have the social media post taken down. Nurse Davis sent Conrath an email showing a post made by Cohoon when Cohoon stayed his file and following it home, so he showed the post. The sheriffs understood from the nurse that the post had been made after they returned from the hospital, after they tested negative for COVID-19. Nurse Davis also advised Sheriff Conrath that the social media post was creating unfounded concern, disturbance, and panic from students who had been on the same trip, and other individuals who had been on the trip, and even from people who had simply seen the posting. All right. Response. Undisputed that Nurse Davis told Sheriff Conrath that. Which, we're kind of where we need to be at this point to rule against Amyiah. The nurse had every reason to believe it. Undisputed that they were telling them that, Dispute the characterization that her post was creating unfounded concern. In the minds of the people it was, because of the test. Or the concern was primarily attributable. The ones we're concerned about are. And blah, blah, blah. Yeah. Sheriff Conrath was advised the health department received several calls from community members who were concerned. So the sheriff is also being advised about this. These calls were negatively impacting the resources. Dispute the implication of the strain of resources was primarily attributable. The ones we care about are. Sheriff Conrath was also advised that school officials were forced to respond to the repeated inquiries. Undisputed. The media post was concerning the sheriff as well because it appeared to convey false information. Yes, that is key in this sentence. Appeared to convey, given the negative results. Response. Dispute the characterization of the post as false, which strictly speaking they didn't do. It appeared to be false is not the same thing as false. The doctors told them they may have negative tests, and the test said some things. That's great. It was also concerning because it was causing a panic, concern, and disturbance. Dispute the characterization as primarily attributable. The ones we care about are. The ones we care about are. Yes, we care about those. We do care about those parents and those people making those calls. Those are providing a strain on resources at the time when, resources might be better spent somewhere else. So it is presenting a concern that is notable here. Yes. It was the sheriff's understanding these individuals understandably expressed concern over whether they had been infected in light of the trip. Given the panic, concern, and disturbance created by the post and the fact they actually tested negative, the nurse requested them to talk it down, disputed as being primarily attributable. The ones we care about are. Dispute evidence they've submitted, panic, concern, and disturbance. The community we care about is. The community we care about is being panicked, disturbed. We're there. We're there. We are there. If we were doing disturbance inside of Starbucks, our relevant people would be the people in the Starbucks. If that's one person, 5 people, 10 people, or 100 people in a particularly crowded Starbucks in the long, long ago when people used to be crowded in the Starbucks. So yes, the people we care about might be a very small population, but they're the people we care about. We don't care about the big wide world. We are concerned about the people in the Starbucks, however many they are. We are concerned about these parents, however many they are. They are providing a strain on resources. That is notable. It is a concern. The sheriff relayed to the sergeant that they made a post. The sheriff also told him that such a post was concerning, as it was conveying false information, which is what they believed, and was creating a disturbance panic. A dispute that it was primarily attributable. The ones we care about are. Sheriff explained to Columb that the school district was having its resources depleted. Dispute the characterization was primarily attributable. The ones we care about are. Yes, I'm disagreeing with your proposed statements of fact. I disagree with you that these are correct. Sheriff Conrath forwarded Sergeant Klump the email to the social media post and requested that they make the contact. Disputed that the sheriff directed Sergeant Klump to make only a voluntary request. Okay, fair. Did he make only a voluntary request? Okay. Sergeant Klump told the Cones that if MOA post doesn't come, they directed me to. That might have been a lie. Sergeant Klump incident report stated that sheriff had told him to report the response and have the post removed, which isn't quite the same thing as saying make an arrest. And notice they threatened citation arrest while I was there, which is factually true of what he said, but not necessarily factually true of what the sergeant or what the sheriff said. And the sheriff reviewed and approved the incident report, which again is it's an accurate response of the incident. Yes, the sheriff is signing off on the incident report because it's accurate. Yes, he did make a threat of arrest. Yes, that did happen. Does that mean that the sheriff directed it? No. That's not the same thing. The sheriff signing off on the sergeant made the threat. Yeah, he made the threat. Doesn't mean that it was directed. And in spite of letters sent to him, they refused to acknowledge he's free to post what she did or provide assurances that she not be cited if she reported. A little bit immaterial to what's going on. So the evidence that we have, which is merely the depositions of the sheriff and the sergeant, but we want to go to summary judgment. So Amyiah's lawyers are happy with that. They don't want to do a deposition or do anything else. They're happy with that. So the only evidence that I, the trier of fact, have, that's material to this particular issue is the statements and the affidavits of the sheriff and the deputy. And the affidavits say that it wasn't, that last bit was withheld back, that they were directed to try to get taken down, and if not, call me for further action. So the sheriff said, I didn't direct him to arrest. I directed him to have it taken down. And if that didn't happen, then call me and we'll decide on the issue of arrest. And since I have nothing that disputes that, that's factually what occurred. The sheriff withheld that last bit of authority. And the sergeant, when he said, I've been directed to, lied. Which the police can lie. He used it as a means to get what he wanted. Okay. I find as a matter of fact that the sheriff did not direct the sergeant to arrest. Good times. Look how happy I am. If Amyiah would not agree to remove the post, Sergeant mentioned that could proceed with several options. Dispute the implication the sheriff did not order Sergeant Clump to do what he did. It doesn't seem implied from what we see. The sheriff discussed with there be a wide range of options. Dispute the implication, did not order it. I don't know on what basis you can say that you didn't make the order. The affidavits say that they didn't make the order. You don't have any evidence to the contrary. You don't have any evidence to the contrary. So, Sheriff Conrath never directed the sergeant to arrest or issue a conduct if they did not reprove. Disputed. Sergeant Clump told the Cohens that if the post doesn't come out, he's directing me to issue. Yes, I acknowledge as your judge. I acknowledge as your judge that he said that. But that's not the same thing. It's not the same thing. Was he directed to do it? Or did he say it? Are two different things. He said he was directed. Has an employee ever lied about what their boss told them to do to someone else? Of course. People do it all the time. But what did the boss actually direct? And the evidence that we have is their affidavits. And according to the affidavits, it wasn't directed. And we have nothing to contradict that. This statement doesn't contradict that. Likewise, the incident report states that sheriff told him to respond to the incident and have the post removed, which is true. And notes that he threatened citation arrest while being through, which is true. And Sheriff Conrath reviewed and approved the report, which is true. All those things, in fact, occurred. And despite a letter, we're not doing anything. So you can't get where you want to be. You can't get to the threat of arrest. Now, the go in there and have it taken down or order them taken down might be enough, but it's not quite the same thing as saying we were ordering them to arrest, which we weren't. Because according to the sheriff and the deputy, which is the only evidence we have, or the sheriff and the sergeant, I apologize. According to the sheriff and the sergeant, the only evidence we have is that the sheriff said, get it taken down, and if they don't, call me, and we'll discuss what to do next. And we may arrest. They held that last little bit back. That's material, man. It's material. Rather, if Miss Cohn refused to take down the post, the patrol sergeant Clump would assess the situation further. Dispute the implication and did not order. You have no basis to dispute it. You have no basis to dispute it. Sergeant Clump would contact before proceeding with any further action. Dispute that. You don't have no basis to dispute it. The law enforcement contact was the subject of both audio and video recording. Undisputed. Upon arriving at the home, Sergeant Clump requested to speak with the father, Mr. Richard. Richard is our man. Rick is our man. We love Rick. And stepped outside, undisputed. Sergeant Clump initially asked Mr. Cohn questions about his daughter's school trips and where she thought she had COVID. Yes. Mr. Cohn began to explain the hospital course and offered to show documents. Stepped inside the briefly, presumably to ask the documents to be brought outside, and then reemerged and indicated they bring the record. Undisputed. And we saw that. Shortly thereafter, Mrs. Cohn. Shortly thereafter, Mrs. Cohn provided Patrol Sergeant Clump with Divine Savior's record, which he reviewed. While provided with his record, Sergeant Clump never said anything remotely similar to the allegation contained in the complaint, that he was not there to get information just to complete the orders. Disputed in part. Rick attempted to explain this to Clump at least 6 different times. The doctors believed it, even though she tested. Sergeant Clump demonstrated he was not innocent in this explanation, saying, I don't know the circumstances you're in. All I'm here to figure it out, seeing that she got tested and we need to get taken down. Okay, I believe you. I accept that as true. Rather, Mr. Coon directed Miss Coon's medical history over the course. This included information concerning the test had been for COVID-19. Undisputed. Confirms the negative test. Undisputed. At approximately whatever time in the video, explained the reason to be there was stating that she beat COVID-19 even though it tested negative. Undisputed. Clump relayed to the post was causing concerns. Undisputed. Clump explained that Conrath had been in contact with the health department and to see if she would delete her post. Disputed in port. Clump told the Cohens that they were to get her to delete this and asked them to provide a new post apologizing, to which response was, well, we're not going to do that. We don't know that. Mrs. Coon responded, okay, while Patrol Clump agreed to interpret as her agreement to take it down, even though we understood Mrs. Coon may not have been speaking for her daughter, who actually had the authority to author the post. Well, the legal authority belongs with the parents. The legal authority belongs with the parents to direct it to be taken down. So, we approximately whatever time in the video, Miss Coon, that's Amyiah stepped outside the residence for the first time. Sergeant Clump explained to the Cohn family that always there to figure out what the post was about, seeing the test was negative and see if he would take it down. Disputed. Sergeant Clump did not tell Amyiah there to see if she would take the post taken down. Barry said, I don't know the circumstances. All I'm there is to get it to take it down. A demand, not a request. Fair, accepted as true. In response, Amyiah immediately responded by saying, I do it. Yes, as did Amyiah, a mother, it seems. Yeah. Sergeant Clump then took the statement to be voluntary willingness. Disputed. Regardless of what Clump understood, the video shows Amyiah responded to the demand, which does not suggest voluntarily willingness. Well, we could get into the nitty-gritty of whether or not that was perceived as a threat or directive or request or whatever, but her mother was there, and as I remember, basically undermined Rick. Rick was doing fine. Maya's mother kind of undermined Rick. Rick's mother, or Maya's mother, was trying to seek the peace, and Rick was standing up for the constitutional rights. On this Memorial Day, I say, you go, Rick. You stand up for those constitutional rights our founders guaranteed to us. You are my hero, Rick. I love you, Rick. I'm really, really sorry you're going to lose your lawsuit. I really wish you wouldn't. You're my hero, Rick. I'm sorry about all this. I really am. Sergeant Clump spoke with Miss Cohen, further explained the situation while I was there. He's informed that Miss Cohen began with her in Florida. He's concerned about COVID-19. After additional conversation in the medical course during the past week, nonetheless, can we get it taken down? In response to the question, both Miss Cohen and Mr. Cohen apologized. Let me do that again. Apologize. In response to the question, both Amyiah and her mother immediately responded by saying yes. Undisputed but incomplete. Immediately thereafter objected, wait a minute, why does it need to come down? Why has it been violated here lawfully? Yeah, we have two people with authority giving contradictory commands, and the police can probably reasonably rely on either one, and we could get into interesting questions like, because can we get it taken down could be perceived as a request. We need to get it taken down, which was said earlier. So we might get into issues of, were they responding to the request? Can we get it taken down rather than, we could get into issues of stuff, but I don't think we need to actually get into any of those issues. I should interview Rick. I should put in an email for Rick. I'll tell you what. If any of for that matter, if the sheriff wants to comment, I know he doesn't because he's been directed by his lawyer, and there's no way he would. But if any of the principals in this story would like to comment on the record, they are more than free to comment me. So if Maya's father, her mother, the sheriff, or the deputy, if any of those 5 people want to contact me with their opinion and whatever, we can have a conversation. If Rick is out there somewhere, if you're watching this and you want to talk to me, I'll be happy to talk to you. And I'll be able to say what was done to you was wrong. You're still going to lose. Really, really sorry about it. You're going to lose, but it was definitely wrong. And you were doing a great job by defending your rights, and you should have defended them further. And unfortunately, Maya's mother was, undermining your authority a little bit, and there were problems as a result. But Rick, you're doing a great job over there. You shine on. You have my approval. You won my heart when the deputy said, "You're not understanding me," and you responded with, "We're not understanding each other." That's when you won me over. We're not understanding each other. I thought that was such a great response. It was epic. Sergeant Klump took Amyiah's statement to express voluntary willingness, disputed. Regardless of what they understood, does not show voluntary willingness. Up to that point in time, Amyiah had twice indicated agreement that she'd remove the post. Sergeant Klump never suggested, insinuated, or threatened that anyone could face arrest if there's not agreement. Disputed. A deputy sheriff at one's doorstep demanding removal, "We need to get taken down," is an implicit threat. Fair. And Sergeant Klump reinforced the coercive implication by failing to disavow any threat of what has been violated here lawfully. Fair. That at that point, that was true, but then we could get into issues of whether or not later on they're responding to a request or blah blah blah, and yeah. So was it voluntary? As a matter of fact, was it voluntary? That's a tougher question. Because I'm trying to look through this legally. I'm trying to get into the coercive statements. I'm trying to get through the point that both of her guardians are there and have the ability to speak for her. And where that all lines. So was it voluntary? I guess it depends which one. Probably by the time it was ultimately deleted, it's close. It's a close issue. It's close. And it's close because of Amyiah's mother. Amyiah's mother, who is a fully grown adult and in a position to defend the First Amendment, is undermining her daughter's legal position. It's close. Whether it's consensual or not, it's close. At approximately whatever time on the video, they walked inside and closed the door behind her. While Amyiah was outside with the presence, and after Amyiah had already twice indicated she removed it, approximately, Sergeant Klump stated, outside of the presence, Amyiah wasn't in the video at this point. He stated, "Richard, I don't want to go this far, simply as me coming down here and just getting the post taking and walking away." After Amyiah agreed to take down the post, and while Amyiah was inside, presumably to take down the post, Sergeant Klump did tell Amyiah's father, Rick, our hero, that penalty for disorderly conduct due to the fact it was causing disturbance. Undisputed, but if complete. Sergeant Klump stated, if it doesn't come down, he's directed me to issue citations, if not start taking people to jail. Yes, I accept that as true. It was only after Amyiah had already twice agreed to remove the social media post that it made any statement about the potential for disorderly conduct. Dispute the characterization of twice willingness to be taken down. That is also factually relevant. Like the sheriff or his deputy. The sheriff's deputy was being a pretty good deputy. I want to say it too. He's doing a pretty good job as a deputy. He's coming in, he's trying to escalate this slowly. He doesn't want to come out and make the most overt statement. So he's coming in at hence first, right? We need to get it taken down. Would you take it down? Before we move to stuff. So he's going along a path of escalation. And the very fact he did that is providing him cover and providing me changes in my analysis as I try to look to the facts and who knew what and when and who was acting and why. So the sheriff's deputy was actually doing pretty good as a deputy. He did slightly err by starting with it needs to come down rather than we'd like it to come down. So he did err in one word choice. That was a bit of a mistake on his part. But otherwise, Sheriff Conrath, you've done a pretty good job of training your deputy. He's well versed on the ideas that you have taught him. He did a pretty good job. following the path. And because he did a pretty good job, he's helping to insulate you from liability. So good job, Sheriff Conrath, on your training, I guess. Good work. When Sergeant Klump made these statements about disorderly conduct, Amyiah was not present. Undisputed but incomplete, the video shows Amyiah learned while Sergeant Klump was still there that she had threatened the family with jail over the posts. I'm not sure the video reflects that. No. I'm not sure the video reflects that Amyiah learned that her family was threatened with jail. I don't quite remember anything that we could say objectively Amyiah learned that. Now, it's probably true, because Amyiah was probably within earshot of this, but we don't know that based on the video. So I don't know that I can't agree based on what I saw that Amyiah learned that from the video that she learned about that. Maybe it's in her affidavit, but we don't know that from the video, I don't think. After Amyiah removed the post that Klump had a screenshot of, she remained outside while her father continued to discuss, and Rick twice protested the threat of jail, and Sergeant Klump continued the threat in Amyiah's presence. You guys want to threaten someone to go to jail with it and add insult to injury. It doesn't do any good when you can't warn people. Sheriff's office. But it's not the deputy making the statements. It's Amyiah's father, which might be material. And at what point is this in this exchange? And what did Amyiah, was she had already deleted it or not? Yeah. After she removed the post was when this video occurred, because that's what the grammar says. Okay. All right. Wow. Yeah. So that was tricky language, and I didn't even pick up on it at first. Okay, that's why I couldn't quite get there. So yes, the video shows that Amyiah learned while he was there the family is jailed. Yes, the video does show that. But that wasn't what I was thinking of. I was like, does the video actually show that? Because I was thinking about when the post was actually deleted. And when the post is deleted is presumably the point of injury. So that's the point of injury, because the First Amendment right has been silenced. And only after that you learned, oh, if you didn't do that, I was going to arrest you. I'm not sure it matters anymore. So yeah, that doesn't matter at that point. We can only really rely on the stuff that was made before the decision to delete, because that's the point of injury. So anything that happens after that point doesn't seem to really matter. It matters a little bit in terms of ongoing issues. So it matters a little bit in terms of declaratory relief, but it doesn't really matter in terms of the underlying liability of this incident. The underlying liability of the incident occurs when the action is complete. Like any crime or any tort, we look to when it's complete. When is it complete? Well, I think it's complete when she deletes it. That's when it's complete. And so anything that's after that doesn't matter, because it's complete. That's what complete would mean. So it doesn't matter. So sure, she learned about it, it just doesn't matter. Sergeant Klump did not have plans to issue citations or make any referrals, even if Amyiah would not agree. Disputed. Sergeant Klump told them that if they did, they would do it. Yes, they told them, but that's not the same thing. That's not the same thing. What's going on in their own head and what they say is not the same thing. So what they said is Sergeant Klump did not have plans to issue citations. Now, he said it, but did he actually have plans? I mean, the statement is indicative, maybe, but it's also not indicative. It's not necessarily the same thing. And the sergeant, again, and goes to all we have, because both sides moved for summary judgment, all we have is their affidavits. So, as a matter of fact, we know what was going through his head, because we are the triers of fact. We have to decide what the facts are. So what are the facts? Well, we can now determine what the facts are. We can determine, for a matter of fact, that in his own head, subjectively, he didn't have plans. How can we determine that? Because we have his affidavit, and there's nothing that contradicts that. So that's subjectively what was going through his head. We can determine that for a matter of fact. So we know his statement was not in conjunction with his subjective state of mind, because he told us, and there's nothing that contradicts that. So that is, as a judge, that is a finding of fact. As a finding of fact, he did not, in fact, intend to arrest. I know that because he told me, and there's nothing that contradicts that. His statement doesn't contradict that. It doesn't go to his subjective intention. It would go to what Amyiah perceived, for sure. It would go to what Rick perceived, for sure. No problem. What they perceived, no problem. No problem. What they perceived. But what's actually going on in the deputy's head? Well, we're on summary judgment, man. We know what's going on in his head. He didn't intend to arrest. That is factually now what is happening. That is now a fact. Sergeant Klump had previously discussed with Sheriff Conrath that there were a wide range of options. While this potential included disorderly conduct, it also included some other people. Dispute the implication. You have no basis to dispute it. If Amyiah refused to take the post down, Sergeant Klump would have further evaluated the situation, discussed the situation. Disputed. Sergeant Klump told them that said this. Yes, we all get it, Rick. Or apologize. That isn't on Rick. I apologize for putting that in Rick's language. I apologize. I'm sorry. That was mean against Rick. I take that back. We all get this, Amyiah's lawyer, who I don't remember your name, and I'm sorry. We all get it. Yes, we all get the statement was made. But you can't dispute it because you're on summary judgment. Sergeant Klump and Sergeant Conrath, or Sheriff Conrath, has said it's true. You can't dispute it. You have no basis to dispute. Yes, he said it, but in fact, that was not their intent. Because you have no basis to dispute. Because they said it's their intent, and yeah. At approximately this time in the video, Maya's mother partially entered the home, presumably checked inside, and stated she's taking it down. Undisputed. Mr. Cohoon, Rick, reemerged from the residence, stated that if it's not taken down, it won't show up. Sergeant Klump got the impression that the father believed and expected the post was already moved, but suggested that he looked at the phone. Yes. The father then appeared to check his own phone to verify. The father then said to Sergeant, I can't understand where you're coming from, but I feel like we're understanding to each other. A little bit, yes. Amyiah reemerged from the house with her phone in hand and reported to the sergeant the social media post had been taken down. Then proceeded to show the sheriff her phone, Conrath, that had been taken down. Sergeant Klump told Amyiah that he appreciated taking it down. At no time did he ever state or threaten Amyiah that if she did not take it down, to arrest. In fact, never made any threats of arrest to Amyiah in a presence that suggested it. Disputed. The deputy sheriff at one's doorstep demanding it that we need to get it taken down is an implicit threat. Probably true, but it might be ameliorated by the later statements, which sounded more like a request. So the sergeant, or the deputy, messed up slightly. He should have led with the request and then led with stronger language. So he messed up his order, but he was trying. He was trying. And Sergeant Klump reinforced this coercive implication by failing to disavow the threat by what has been violated here lawfully. The video also shows a confirmed threat in Amyiah's presence, which was after the fact, I think, and also not said by him. The sergeant never told Amyiah that she did not reprove it, undisputed. Told the parents that if it doesn't come down. Immediately after hearing that, Angela went inside to get Amyiah, so Amyiah didn't hear it. And it's not clear that Amyiah learned it from her mother at that point. It's certainly not on the video. Rick discussed the threat and confirmed it in the presence, which is after the fact, which doesn't matter because the threat is complete. The act is complete. The crime, as it were, is complete. So we don't really care about these statements after the fact. At no time did the father bring Amyiah outside and explain that Amyiah did not delete. She would not delete, but she could decide. Undisputed, the video does not show the statement. But Rick was inside by Amyiah at various points. I don't know that I could swear to it, but I don't remember any point where Rick went inside. Yeah, I might have gone inside at one point. Yeah, okay, so he did go inside. But I don't think he mentioned, oh, by the way, while he was inside. So yes, I think he did go inside very briefly. But, I don't know that was being communicated. It's certainly not that referring to an affidavit where, by the way, while he's inside, we communicated this to Amyiah. That's not being said. By the way, while I was in here, I said this to Amyiah. That's not being said. So it didn't happen, right? So Rick was inside by Amyiah at various points. If Rick at some of those various points had said certain things that you'd like to bring to our attention, that'd be great. But you're not doing that. So I'm assuming it didn't happen. So Rick didn't say anything at those points that were material, so I don't care. The judge does not care because who cares? There's no new information being exchanged. All his interactions were professional and never raised a threat nor threatened with arrest. Disputed. It's an implicit threat. Threaten the parents. Yes, but after the fact. After it's complete, so it doesn't matter. Or am I wrong? Was it complete at that point or not? I forget. I think it was complete at that point. And it was also outside of Maya's presence. And also, like, so maybe I'm getting that backwards. Maybe that wasn't complete at that point, but it was outside of Maya's presence. The information wasn't communicated to Amyiah, and all kinds of stuff. So yeah, it was Sergeant Clump's intention to speak with Ms. Cohoon to explain the negative impact. Disputed is the implication that Sergeant Clump had no intention of doing what he did. Sergeant Clump had significant concerns over the social media post, which was causing unfounded concern. Disputing that it's attributable to Amyiah is that we are concerned about. Yeah. The media post, which was believed to be inaccurate, not only caused a disturbance, but actually did cause a disturbance. Any disturbance was more attributable to the pandemic itself. No, it's really not Amyiah's lawyer. It's really not. The community we're concerned about is being brought on by Amyiah's post. It seems pretty causal. They are certainly primed by the underlying threat, but Amyiah's post is definitely what is causing this to occur. Rick continued to voice his thoughts. Yes, he did. In my experience, she fears posting. Yeah, as to declaratory relief, the Judge Blackleaf would give you declaratory relief. I'd give you some declaratory relief. But that's about it. Sorry. On March the 28th, Rick posted on Facebook about the assumption. In the lengthy posting, Rick stated his version of what took place. Undisputed but irrelevant. Yeah, so Rick is expressing his freedom of speech. Rick has continued to post about the incident by referencing a photograph of Amyiah, forced to remove, undisputed but irrelevant. A highly contagious virus is already resulted in declaring health emergency. Sure, as of this date, there's some cases. There's still no cure. Signed by a guy whose name is also Rick. Well, it's actually technically signed by Luke, but Rick is the first listed attorney. So Rick represents Rick, and Rick the attorney has some problems here. Rick the attorney has some problems here. So now we have some proposed findings of fact from them. So let's see if there's any findings of fact that we don't already have that we care about. Began shutting down, public health emergency, theme parks. I'll just say that all these are true unless they're not. Okay, all these are true unless they're not, because we've read a lot of these before. So the governor ordered this, health service did this, Amyiah did that, 5 or 5 days, ill, fever, testing, self-quarantine, discharge order, the worsened, redirected, tested, test came back negative, doctors told them they had COVID-19, consistent with it, test gave a disclaimer, health experts estimate nearly 1 in 3 people are nevertheless giving results on April 2nd, which is, I think, too late for our purposes. And also it's reported in a newspaper, which means it's inherently untrustworthy. Am I right? Based on what they told above, the people still believe they have symptoms. Fine. They returned home on this date. Great. Left hospital, unable to reach the teacher, left a voicemail. While in hospital, received a principal, told the principal about it. Wanted to update her friends, posted Facebook posts about it. And her first post home, she posted this on March 25th. She posted this on March the 26th. She did this on March the 27th. So yeah, March the 27th. So it's too late. So who cares about what the Washington Post or Wall Street Journal wrote on April the 2nd? It's too late, because the day in question is March the 27th. So I literally do not care in any way about the Wall Street Journal or anyone or what they did on April the 2nd. So Judge Blackleaf strikes as irrelevant that the newspaper reported on April the 2nd, whatever, because we're on March the 27th and I don't care. Stricken as irrelevant. It is no longer a piece of evidence. It doesn't matter. A video recording of this stop has been submitted. The video shows this stuff. The video shows this other stuff. The sheriff said, I don't know the circumstances, need to get it taken down. Quickly will do, blah, blah, blah. Nonetheless, can we get it taken down? Blah, blah, blah. They don't have information. Mid-layer Rick says, I know what's going on. Yes, we all these conversations happen. This is all great. Sheriff incident, okay. Sheriff Clump's incident report stated he went to the home to have the post removed and advised them that there would be a possibility. That's true. That did factually happen. Sergeant Clump asked the sheriff to review the incident, see if he'd like me to take it down. So I review it, and it's inaccurate and to the point. Yeah. Later that evening, they sent a news update. The update was sent, which was based on information they had at the time. Amyiah is upset about this post and concerned about the effect, but she's afraid to respond. Okay. With threats from law enforcement looming over the head, Amyiah has felt unable to respond. Now afraid of returning to school. Not that there's a threat of that happening any point in the near future, I would think, but yeah. Amyiah continues to wish to post about her scare, and she's afraid to do so. The court will give you court Blackleaf will give you declaratory relief. I will give you declaratory relief, but nothing else. Amyiah has not stated anything further. The undersigned counsel sent some letters and some other stuff. Blah blah blah. Great. Okay, so that's the end of that. So now we know everything we need to know. So now we know everything there is to know, except for those two Supreme Court cases on the Monell thing. So I will give you my initial legal finding, and then we will go read those two Supreme Court cases and see if it changes my view as to the respondents, the issue as to the sheriff's responsibility. So we'll go read the Supreme Court cases, but I'll give you my initial findings, which will only be modified with respect to the sheriff at best. But here's my initial findings of fact. Or my initial findings. So yes, I agree with all that stuff. That's all great. We already told you all the facts. I've already gone through and told you what the facts are that I believe are true. So we know that. Here's my conclusions as a matter of law. Again, I wish to state very clearly, for the record, before I say this, I want to state very clearly for the record that this is my view as to what the law is, not as to what I think it should be or what I think is good. Judges sometimes have to make rulings that they don't like. And I'm going to make a ruling I don't like subjectively. I don't think it's not a decision I wish I would reach. But it is a decision the law compels. And so I will reach the conclusion the law compels because it is the decision the law compels, not because I want to. I think Amyiah got done dirty, is what I think. And I think Rick is a hero. But here are my conclusions as a matter of law. I think that the sergeant has qualified immunity. I think he had more than enough information at the time to believe he had probable cause of a disturbance that would qualify within the meaning of the relevant statute. As I have since learned, since doing my earlier readings on this, because I have been reading on this a little bit, as I've since learned, there is case law that stands for the proposition that yes, written language can be used for public disturbance. And there is evidence of a public disturbance that was occurring that was relevant to the relevant community. It's creating a real actual problem that really actually exists. And it is creating a strain on resources to some degree due to that threat, due to that problem. And the sheriff and their deputy, and more to the point, the deputy believed it to be true. And so was acting in good faith on a belief that be true. So actually, I don't technically even have to get to qualified immunity. I can actually rule out even without qualified immunity. So even without qualified immunity, the deputy wins. Even without immunity, the deputy wins. Even without QI, the deputy wins. So QI is not actually going to be even the biggest problem. The biggest problem is going to be at the time he had probable cause. It seems to me, because he had, again, probable cause is a fairly low standard. And he had enough information in view of the fact that he had a confirmed negative test. And at the time, there was no information that the tests were unreliable. And who knows what wrote on what form. And sure, he doesn't know the full circumstance, but he has enough information to believe that there's probable cause, which again is a fairly low standard, that the crime is being committed. So he doesn't even need the QI. Because he has a good faith belief that this is a valid cause of action. So he doesn't even need QI. If he did need QI, then I would say that yes, it's a violation of the constitutional rights because we now know it, but it wasn't clearly established at the time, either factually or legally, but COVID though. So you also lose on the QI. But the QI is actually not going to kill you. You actually lose on the underlying thing. So you lose your cause of action because the actions of the deputy were in compliance with the law on probable cause and because of QI. So you lose. So you can't get a preliminary injunction also because it's a little mooted. You can't get a permanent injunction because law enforcement And also, it's really hard to structure a permanent injunction properly in a way that won't be problematic. But I'll definitely give you declaratory relief. So here's the declaratory relief I will give you. Your declaratory relief was that your statement at the time represented what you believed to be true, and therefore was protected speech at the time you made it. And here's some further declaratory relief. To the extent that you are making statements that you believe to be true, you can continue to make any statements that you reasonably believe to be true. You can continue to make statements that would be protected by the First Amendment. So I'll give you declaratory relief, but that's the best I can do. That is the best I can do. That is the absolute best I can do under this circumstance. So I think the deputy wins. Now, we can get into whether the sheriff wins. First of all, I think the sheriff probably wins. For the same reason that the deputy wins. The sheriff's actions were reasonable. Even if he made the order. So even if they're lying and he did make the order to arrest, if they didn't take it down, the order is lawful. Because again, probable cause. The sheriff has probable cause. The sheriff has all the probable cause he needs. So even if he's lying in his affidavit, it actually doesn't matter. Even if the sheriff told them, go take it down, and if they don't, then conduct the arrest, don't bother contacting me, just do it. The sheriff is insulated. Because the sheriff had probable cause. He had absolutely probable cause. Even if he had been actually aware of these medical records to the contrary, he still had probable cause. Probable cause is a fairly low standard. Yeah, there's some information that goes the other way, but there's enough for probable cause. There's enough for an arrest. So even if he made the direction, he's insulated. So the sheriff is going to win on the underlying thing. The underlying thing was legal. But then if not, then QI. Was it clearly established? No. But then we have to say, well, maybe QI doesn't apply because maybe under Monell we don't do QI, which seems really, really odd. So now we're going to read these two decisions from the U.S. Supreme Court, or at least skim the headnotes, and see if the Rick the attorney, not to be confused with Rick the parent, but if Rick the attorney may be misleading to me, as this is a Supreme Court precedent. Because he writes this, I'm like, really? That seems weird. That doesn't seem like the way the law is. But then we can go look it up and see what the law actually tells us, and then we will be more informed, and we'll be able to form a more reasonable opinion as to if we could get to Monell, if there's liability, which there's not because it was fine. But if there was liability, can we avoid it through QI for the sheriff? I don't know. We're going to look it up and we're going to find out. So if anyone wants to tune out at this point, feel free. Because now we're doing the research. We're doing the research and further analysis portion of today's evening. So if you want to tune out, we've analyzed the case. Rick and Amyiah is going to lose. They probably get the declaratory relief. That's about as good as it's going to get. Okay, so we got two U.S. Supreme Court cases that Rick the attorney says qualified immunity does not apply to Monell claims against local government units, and we cite two U.S. Supreme Court cases for that proposition. Okay, let's give that a try. Let's figure out if that's a thing. So we'll start with the later case. And see what it teaches us, and we'll go from there. Let's see. Let's read this and figure out what the law is. I really like to read these things in PDF. I prefer. Okay, there we go. We got some PDF. Great. So now we got some PDF. So let us read this and see if it changes any of our legal analysis. So I need to just change the input to a different thing. Great. That was easy enough. All right. So here we are. U.S. Supreme Court case. Leatherman versus Turney County. Narcotics Intelligence and Coordination Unit. U.S. Supreme Court, 1992. We will read the syllabus and we will also read their citation. Let's see. filed lawsuit against respondents acting in local capacity to care of two municipal corporations alleging search for narcotics violated Fourth Amendment. The federal district court dismissed because heightened pleading standard adopted which required blah blah blah. Federal court may not adopt a heightened pleading standard than that is required in civil rights case. Okay, a heightened pleading standard may not be justified on the ground. A more relaxed standard would eviscerate the standard. Municipalities, although free from responding at superior liability, do not enjoy absolute or qualified immunity from 1983 suits. Interesting. It seems pretty clear. We'll go to the pinpoint site, because in their case, in their thing, they actually cite it pinpoint. They actually cite an exact page. They cite page 166. It's a pinpoint site. So we'll read the pinpoint site. First, respondents claim that municipalities' freedom from respondent superior liability necessarily includes immunity. In that sense, respondents assert municipalities are no different from state or local officials in their individual capacity. Respondents reason that more relaxed pleading requirement would subject municipalities to expensive and time-consuming discovery. Municipalities are no different than individuals. Okay. This argument wrongly equates freedom from liability with immunity. To be sure, we reaffirmed in Monell that a municipality may not be liable on respondent superior theory, but contrary, this protection against liability does not encompass immunity. Okay. Indeed, this argument is flatly contradicted by Monell and our later decisions imposing municipal liability. In Monell, we overruled a prior case insofar as that local governments were wholly immune from suit under 1983, even though it did reserve decision or when they're entitled to some form of limited immunity. When we took that issue up again, we rejected the claim municipalities should be afforded qualified immunity, much like those afforded to individuals based on good faith. The decisions make clear that unlike various government officials, municipalities do not enjoy immunity from suit, either absolute or qualified. In short, a municipality may be sued under 1983, but cannot be held liability unless the municipality or custom caused the injury, with thus no occasion to consider where qualified immunity require heightened in cases involving local officials. The thing that's giving me a little bit of pause here in terms of analyzing this decision is that they're talking about municipalities, which could be a basis if you were so inclined to distinguish. Because what Rick the lawyer wrote in his case was qualified immunity does not apply to Monell claims against local government units. But what the Supreme Court wrote is slightly different. What the Supreme Court is writing is talking about municipalities. So is that different or distinct? And there might be a basis to distinguish. That's why I'm trying to think if there's a basis to distinguish based on this language. But here they do say local governments in this section. Local governments are wholly immune from suit under 1983. They reserve immunity as some form of immunity. So yeah, Monroe said local governments were immune. So we overruled Monell and said no, local governments are not immune. We rejected the claim the municipalities should be afforded qualified immunity, much like the force based on qualified. So is there a basis to distinguish municipalities from the sheriff's office? There might be. And the reason that I'm thinking that there might be is specifically because it's a law enforcement context. Because 1983 is at its highest in the law enforcement context. Because the underlying principle of qualified immunity is, or the underlying justification for it is, the police officer making the split-second decision. A person reaches for something in their pocket and they start to come out with it. Is it a gun or not? The police officer shoots the guy. It's not a gun. That's qualified immunity, right? Because they have to make a split-second decision. So it's not immediately obvious to me that the Supreme Court's language was talk about municipalities where, it's a city council that's coming up with rules or regulations in a more sobering, deliberative process. It's not clear to me the logic that applies to municipalities would apply to the sheriff's office specifically, because the law enforcement context, I think, may be enough of the change of analysis that it's not clear to me that the legal analysis is right. So I think that because the Supreme Court, the way its language is talking, seems to be talking about municipalities, and there's enough difference of context that's causing me questions in my mind. So if you're wondering why I'm pausing and thinking about it, I'm pausing and thinking about it because the Supreme Court said municipalities. I'm like, is the sheriff's office the same thing or not? That's what I'm thinking about. In case you ever wonder, what is he thinking about? That would be what I'm thinking about. Let's go read this case, Owen versus City of Indianapolis, and see if it provides any further context. City of Independence. I apologize. Independence. City of Independence. I don't want to misstate the city. Where is the case? If I'm on script, just give me the case. Oh no, that's just the law review article. That's why it's on the script. Where is my PDF? Where is my PDF? Great. I got it. Let's see if this case provides any further clarity. So they cite as a pinpoint site 257. City Council moved that reports of investigation of a police department be released to media and turned over the prosecution for presentation. City manager take appropriate action. No, city manager discharged the position, discharged as chief of police. No reason was given for this dismissal. Received only written notice saying that they made pursuant to the charter. Specifically brought a suit under 1983 against the city respondents, saying he's discharged without notice and without a hearing in violation of rights. The district court, after bench trial, entered a judgment for respondents. The Court of Appeals ultimately affirmed, holding although the city had violated rights, nevertheless, including the cities were entitled to qualified immunity on the basis of good faith held. A municipality has no liability from 1983 flowing from constitutional violations. It may not assert violations on top of its good faith. 1983 creates tort liabilities that offers no immunity. When immunity was well established, the state was construed to incorporate the immunity, but to no tradition immunity of municipality corporations. Applicability of rationale, both the doctrine with respect to municipality with government functions and doctrine and discharge of legislative duties, which again is why I think it's material, because the duties in question are more legislative than executive in nature. Principle of sovereign immunity, rejection of construction, blah, blah, blah. Okay, great. And they cite as a pinpoint site 657. So let's see what page 657 has to teach us. It's like all the way at the end of the opinion, isn't it? And 651, 652, 653, 654, 65, 66, 67. 67. Our decision holding municipalities have no immunity flowing from the constitutional violations harmonizes with developments in constitutional law. Doctrines of tort law have significantly changed. Our notions of governmental responsibility should be reflected. No longer is the individual blameworthy the acid test of liability. The principle of equitable law spreading has joined factor. We believe today's decision, consistent with precedent, properly allocates these in the 1983 scenario. The victim of the constitutional deprivation, the officer who caused the injury in the public as represented by the municipal entity. This innocent individual who's harmed is assured he'll be compensated. The offending individual, so long as he conducts himself in good faith, may go about his business secure in knowledge that qualified immunity will protect him. And so this seems to suggest the exact opposite. So I don't know that I agree with Rick, the lawyer, that qualified immunity doesn't work here because it's the sheriff's office. And they were talking about municipalities, and there's enough difference in context because municipalities, when you're thinking about like, because you're thinking about policies of municipalities. So you're thinking about the city council, you're thinking about legislative function, or you're even thinking about like executive orders from a mayor, but you're not thinking about police activities. So the difference in function is enough that I don't read this as applicable. So I don't think that I think QI does apply to the sheriff. If it were the municipality, no. Are we suing the municipality? We're suing the sheriff. If we're suing the city of whatever, then great. But the city of whatever didn't have a policy. The policy was from the sheriff. So the city of whatever can't be responsible because we can't get respondeat superior liability. We can't get vicarious liability. The city government doesn't have a policy. The county government doesn't have a policy. The policy in question is coming from the sheriff. So we can't get to the city. We can't get to the county. We can only get to the sheriff because of their policy. And I think qualified immunity applies because the nature and the functions are different, and I don't think the Supreme Court case reads on it. So Judge Blackleaf, as a matter of law, disagrees with your conclusion of law, attorney advocate Rick. I don't think that that's right. I think QI does apply. Not that it matters, because I think the sheriff wins under the underlying thing that they don't even need QI. So that's sort of where I sit on all that. But you got two additional Supreme Court cases worth of education today. Wasn't that exciting? You got two additional Supreme Court cases worth of education as we read this. And we're like, wait a second. That doesn't seem right. And I read it and I'm like, that doesn't seem right. Doesn't seem right. The context is different. I don't think you apply one on the other. It's not obvious that you do. So, yeah. I don't think you can get liability for anybody. I don't think you can't get liability from the health department because they apparently have the ability to make these reports. You can't get liability for them reporting the issue to the sheriff's department because they believed it to be true. You can't get liability to the sheriff's department. You can't get liability for the superintendent. He believed it to be true. You can't even get defamation because you can't get defamation because you can't get to the negligence that you need. That's the problem. So normally in like standard defamation law, we don't normally talk about it that much because it's usually pretty implied, but we actually have to talk about it. You can't even get to negligence. So for defamation, it has to be false and it has to be communicated and published with a third party, but it also has to be made with at least negligence. And there isn't negligence because he made it in good faith on the basis of the report he was giving. So you can't get to defamation. You can't get to defamation. You can't get to the county. You can't get to the school board. You can't get to the nurses. You can't get to anybody. Everybody's acting reasonably. There's no causes of action against anybody. I just can't get anybody. Now, you can't get to defamation. You can't get to defamation because the school believed it to be true. You can't get to defamation. The school believed it to be true at the time they made the statements. They weren't made negligently. You can't get to defamation. No, you have no causes of action here. The sheriffs were acting in good faith based on the information they had and probable cause. And if they didn't, they have QI. So my prediction for this case is going and blowing up. This case is going away. I think the most you can reasonably hope for is declaratory relief from the judge. If you get that, the judge might just dismiss it altogether. I don't see really any avenue for anything other than happening. You're definitely not getting the preliminary injunction. You're not getting a permanent injunction, and I don't see any underlying liability based on my reading of the case law. So Judge Blackleaf does not think there's anything here. Sucks. Sorry, Rick. Sorry, Amyiah. I don't want to roll against you. I like you. I really do. I don't want to roll against you. I really don't. But it's what the law requires. Yeah. Daniel says to the diagnosis they mean has nothing. You have to mean something to who? That's the issue. It means to who? It means something to Amyiah. It means something to her father, Rick. It's statements that they can reasonably rely on. So her speech is protected because it is perceived to be, it is true. From their point of view, it's protected speech. So it means something to them. Does it mean something to the sheriff? Well, first of all, the sheriff didn't know about it. Does it mean something to the sergeant? On a probable cause standard? No. It's not immediately obvious. The test is the best information I have. It's by far and away the best information. This work release thing which says COVID. I don't know what that says. I don't know why that says that. I don't know why that says that. On a probable cause standard? No. We can get to probable cause. Yeah, we can get to probable cause. Yeah. So it, I don't think, Matthew, you're right. Because I believe that the school officials at least had reports of the county's test. If the school officials when they sent out their emails at least had that much information, then I think they can rely on that information. It's not negligent. That's the standard we're trying to reach for defamation. So, despite anything else that's in the file, as long as the school officials when they sent out that email, as long as they knew about the negative test, as long as they had that much information, the statement can't be negligently made. How is it possibly negligent? Even if you had information that went the other way, it's not negligent to rely on the test. So it doesn't meet negligence. So you can't get there. Yeah, everyone acted in good faith. So you can't get to where you need to be. As long as the school administrator had knowledge of the test, he's good. Even if he had other pieces of knowledge, he's good. He can rely on that piece of information. And it's not negligent. You can't get to where you want to be. So, yeah. Sorry, Amyiah. I really am. I'm really, really sorry. By the way, I don't know if anyone's commented on it yet, but I added a Texas flag thing in the corner on my wall so that people would know Texas. So, Texas flag. I don't know if anyone noticed, but it's up there in the corner now. It lives there now. If you liked this stream, if you liked this stream, not necessarily the result, but if you liked this stream, I'd appreciate it if you give me a like. And as always, I appreciate your super chats. It's always helpful. I appreciate it very, very much. We might be on later today with more batch recording. I still have like 3 other stories I wanted to record Sunday, and I lost of energy. So, yeah, well, I don't think it was the principal that called her a liar. I think it was the superintendent that called her a liar. Yes, the superintendent called her a liar. But as long as he knew about the report, as long as he knew about the health report, it's not negligently made. So, good times. I think it's just a placeholder, though. I'm thinking about getting like an actual like a framed canvas thing of Texas flag and replacing the picture. But that's just like a cheap metal thing, just there to like sit there for a little bit while I look for better pieces of art. But I want people to know. But Texas, though. Yeah. So, good times. Anyways, I'll talk to you later. It's been a pleasure. Till later, my friends. Peace. Goodbye.